Council has. Good morning again, Your Honor. Courtney Emerson on behalf of the applicant. Council has previously circulated and reviewed an exhibit list, which was provided to Your Honor in advance of today's hearing. Those are exhibits 1 through 25 inclusive, and absent any objection from the other council, we would move that exhibits 1 through 25 be admitted into the record. One of the exhibits was voluminous, actually two, but one is for cross-examination. The one for direct examination has a blue paper sitting in front of the court reporter, and that is exhibit 1 to exhibit 4, which is the rebuttal testimony of Dylan D'Ascendis. All of the other exhibits are contained in binders that were distributed to each of the council, the court reporter, and Your Honor.
Are you going to move those into the record, Ms. Emerson?
Yes, I would move those into the record.
I'd like to see if there's any objection to that.
No objection from the DPA, Your Honor.
Crumpler.
No objection from staff.
With unanimous consent, then, the exhibits that's proffered by Ms. Emerson that are sitting on the table and next to the court reporter inclusive are entered into the record.
Thank you, Your Honor.
Ms. Emerson, do you have any other preliminary matters?
Yes, council would like to stipulate on the record that the applicable standard of review for this proceeding would be the business judgment rule, as opposed to the prudence standard of review, which was enacted after this hearing. Council had previously provided information on those two standards to Your Honor. So absent any objection, we would move and stipulate on the record that the business judgment rule would apply to this proceeding.
Mr. Crumpler.
DPA is in agreement with that.
Ms. Workman.
Staff is in agreement.
Thank you. That's agreed to. There are no other preliminary matters then. We'll turn it over to Ms. Emerson to call her first witness.
Thank you, Your Honor. The applicant calls Timothy Lyons as its first witness. Tim Lyons is on Zoom, I believe. Tim, can you hear us?
Yes, I can.
Okay, great. Yes, please.
Mr. Lyons, can you please state your name?
Yes, it's Timothy S. Lyons.
Sir, would you raise your right hand, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Mr. Lyons' testimony is at Exhibit 1 and Exhibit 2. Mr. Lyons, although you just did it, could you please state your name and business address for the record?
Yes, it's Timothy S. Lyons. My business address is 1 Speen Street, Framingham, Massachusetts, 01701.
By whom are you employed and in what capacity?
Employed by Scott Madden as a partner.
Can you briefly describe your responsibilities in that role, please?
Yes, I support clients in rate case proceedings such as this.
Did you prepare and cause to be filed testimony in this proceeding?
Yes, I did.
Can you please identify the type and date of each testimony you filed?
Yes, I filed direct testimony on April 4th of 2025. I filed rebuttal testimony April 17th of 2026.
Thank you. Were your testimony and any associated schedules or exhibits prepared by you or under your direction and supervision?
Yes, they were.
Do you have any corrections, updates, or clarifications to your testimony as filed?
Yes, I do. I have corrections on 3 pages. On page 14, on line 14, page 14, line 14, the sentence that reads, number of bills were used to allocate meter and service costs, replace meter and service costs with customer services cost.
Excuse me, Mr. Lyons, what line was that?
Beginning on line 14, all the way toward the right, the sentence starts with number of bills were used to allocate meter and service cost. So where it says meter and service cost, replace that with customer services cost.
Thank you.
And then on line 15, about 2/3 way over to the right, there's a sentence that starts ERCs were used to allocate customer services cost. Customer services cost should be replaced with meter and service cost. In other words, those two were just flipped.
Thank you.
Mr. Lyons, I understood you had one more correction to page
Yeah.
19.
Yeah, there's 2 additional pages. On the very next page, on page 15, on line 7, where it says figure 3, it's basically the same correction from the prior page where it says meter and services. That should read number of ERCs. Right now it reads number of bills, should read number of ERCs. And then in the line below, it says billing and accounting. That should read number of bills rather than number of ERCs. Again, those two are just flipped.
Thank you.
And then when that's completed, I just have one more. And that's on page 19. And on page 19, there's a footnote number 3. At the very end of that footnote, there's page reference of 138 to 130. That should read 138 to 139. So replace the 130 with 139.
Thank you, Mr. Lyons. Acknowledging those updates, if I asked you the same questions today, would your answers be the same?
Yes, they would.
Do you adopt your previously filed testimony, including all schedules and exhibits, as your testimony in this hearing?
Yes, I do.
And are the schedules and exhibits attached to your testimony the same as those filed in this proceeding?
Yes, they are.
And to your knowledge, are those schedules and exhibits true and accurate to the best of your knowledge and belief?
Yes.
Thank you. Mr. Lyons is available for cross-examination.
Your Honor, Stephen Ferguson on behalf of staff.
Excuse me?
Stephen Ferguson on behalf of staff for cross.
Yes.
May I proceed, Your Honor?
Yes, sir.
Good morning, Mr. Lyons.
Good morning.
Can you hear me clearly?
Yes, I can.
And do you have a copy of your rebuttal testimony handy?
Yes, I do.
Are you sponsoring Artesian's class cost of service study and proposed rate design?
Yes, I am.
Did Artesian agree to perform a customer demand study as part of the settlement in the last rate case?
That is my understanding, yes.
Have you or your firm completed a water demand study on behalf of Artesian as contemplated by that settlement?
We've completed a water demand study based on the available data that we have.
In your rebuttal testimony at page 4, lines 2 through 4, you state that Artesian does not have the daily and hourly load data, and to obtain this data would require installation of new metering technology. Is that correct?
Yes, that's correct. I would add that the daily and hourly load data that's referenced here is at the customer level. The company does have that information at the system level.
Are you suggesting that new meters would need to be installed for all customers or just a sample of customers within each rate class?
I'll let the company discuss the metering technology that would be required, but the data is not available at the customer level to look at either hourly or daily demands.
But would you suggest that it be installed for all customers or just a sample of customers within each rate class?
In this case, where it's referencing a load study, that would be based on a sample.
Okay, thank you. Do you know what it would cost to perform a demand study?
I guess there's several pieces related to that. One, there's the data collection piece, which is actually collecting customer level data, both on an hourly and a daily basis. So it requires some metering, some collection system, some transmitting system. So all of those costs would be related to the infrastructure side. And then there's the analysis side, which is what we did in this study, utilizing the data that was available. So there'd be two pieces to that.
So for both of the pieces you just described, do you know what the cost would be to perform the demand study completely?
I do not. I don't have those figures available.
If you could look at your rebuttal testimony, page 4, lines 13 to 14, you indicate that data collection for daily and hourly load data takes time and would not have been available to utilize in this rate case. Is that correct?
Yes, that's correct.
Was there time since the approval of the settlement in the last rate case for Artesian to collect the required data and complete a demand study prior to the filing of this rate case?
No, I don't believe so.
If you could look at your rebuttal testimony at page 11, lines 14 to 15, you state that Artesian prepared an updated meter and service study as part of your rebuttal filing. Is that correct?
Yes, that's correct.
Why was an updated meter and service study not done as part of the company's direct case?
Our focus on the direct case was on the demand study.
So staff and the DPA did not have an opportunity to respond to the updated meter and service study through written testimony in this case, correct? Because it was submitted on rebuttal?
I believe so.
Have you now utilized the new meter study for your proposed meter rates?
Yes, there was a cost of service study and rate design that was filed as part of the rebuttal, and all of that includes the new meter and service cost information.
And what effect did the new meter study have on your proposed meter rates?
It was minimal.
In your rebuttal testimony at page 18, you discuss readiness to serve charge, correct? Do you see that?
Yes, I do. And if I could complete the earlier response, in figure 3, which is on page 12 of 21, that contains what the class revenue requirement would be with the updated meter and service study. So the left-hand column has the updated revenue requirement that includes the meter and service study. And then the right column that begins with 62.2 million, that's from the direct filing.
Okay, thank you. So returning to my last question, your rebuttal testimony, page 18, you discuss readiness to serve charge. Is that correct?
Yes, that's correct.
By how much does this increase the monthly customer charge for residential customers?
I don't have the immediate answer for that, but I will say that the readiness to serve amount is 50% of what's been classified as max day costs. And if you go to my direct testimony, you go to page 13 of my direct testimony, you can see that max day relative to the total cost of service in the graphic in figure 2 represents about 8.2% of the total cost of service. So where the readiness to serve represents 50% of that, so it would be around 4.1% of the cost of service. is related to that readiness to serve.
And this charge will be paid by customers regardless of the individual customer's actual demand or usage, correct?
Yes, that's correct.
So a customer who uses very little system capacity would be charged the same as a customer who has a large irrigation system or a large house with high water capacity demand and capacity needs. Is that correct?
Yes, and it also would mean that on very low usage years and high usage years that they would be paying that amount as well, same amount.
Thank you. No further questions from staff.
Crumpler.
Sure. Mr. Lyons, can you hear me okay?
Yes, I can. Thank you.
Okay. A few days ago, I forwarded to your co-counsel what is actually still part of Mr. Watkins' exhibit testimonies, and it's a document entitled "Principles of Water Rates, Fees, and Charges." Do you have that document?
Yes, I do.
Okay. And sir, you're familiar with Mr. Watkins' testimony in this matter, correct?
Generally familiar. Yes.
Okay. And you have a copy of his testimony?
Yes, I do.
All right. I want to look at page 48 of his testimony. Give me a second. I'll let you take your time as well. Let me know when you're there, sir.
I am there.
Okay. And he's quoting from this manual. He says, formal demand studies involve daily and hourly consumption records of samples of customers from each class of service and are analyzed over a period of weeks or months. With the increasingly availability of automated meter reading equipment, enhanced billing software, and data processing capabilities. These formal demand studies, although still costly, are not as difficult or costly as they were in the past. However, they are not without cost, and there are less sophisticated, though adequate calculations that may be employed to estimate customer class peaking factors using readily available data in the utilities records. And then he says, quotes, "This appendix offers relatively straightforward procedures that can be used in developing customer class peaking factors from system demand data and customer billing records that are available to many utilities." Now, regarding what he just quoted there from this document, did Artesian do a formal demand study, sir?
Now, as I mentioned earlier, there wasn't either hourly or daily load data at the customer level to be able to do the type of study that's talked about here. However, what was done was what's talked about here as the less sophisticated, though adequate calculations. That was the demand study that was done in this case.
Okay. So what Artesian did here was a less sophisticated approach, correct?
Yes, referencing this language here, according to this.
Okay. And so Artesian didn't follow the principles from this document then?
No, I think they did. The data wasn't available to be able to do the quoting, or what's quoted here as the formal demand study, because it involved daily and hourly consumption data from customers. Instead, what they did was this second one, the adequate calculations that can be employed to estimate customer class peaking factors with billing data that's available. So it's based on actual meter reads and actual billing data.
Okay. Do you have a copy of David Schbach's rebuttal testimony handy?
I do
Thanks,
not.
Okay. Are you aware what his Exhibit 1, Schedule 3A2 said?
I am not.
Okay. Do you have any dispute his exhibit that says that there's a residential increase of 13.47%?
Subject to check, I'll accept that.
Okay. And do you have any reason to dispute, subject to check, as you just said, that the overall system percent increase is 10.9%?
Again, subject to check.
Those are all my questions for the moment.
The company has no further questions for Mr. Lyons.
Ms. Emerson, I'm going to ask this question and to others so don't feel transgressed. Is there a, do you have, maybe Mr. Lyons or maybe one of the other members here, can you tell me approximately what the difference in the revenue would be with respect to your positions compared to the company's position? Is that a fair question? Let me start with Mr. Crumpler. Do you have an estimate of that, Mr. Crumpler, or is there a schedule that I didn't see or didn't?
I don't have it handy, Your Honor. I'd have to double check that.
I'm sorry, I missed that.
I don't have it handy, Your Honor. I'd have to look.
Same. I don't have that information.
Ms. Emerson, do any of your people have that number readily available?
We have a lot of boxes everywhere, Your Honor, but I guess
I'm sorry, please.
I was just making a joke about the number of documents we have in front of us, but
I'm going to ask this question a lot, so get ready for it.
Mr. Spate is available to address your question, Your Honor.
Yes, the only difference between the testimonies right now, and let me just start at the beginning. We did not adjust our cost of service from the original filing based upon changes in some of the expenses and the revenues as they were updated. We assumed at the end of this all that the parties would agree to put the required numbers into the studies and the collective cost of service. Witnesses would get together and agree on those. As for the status of the cost of service today, the only input we had from the other witnesses, and they can correct me on the stand, was the requirement or recommendation to hold the fixed cost at the current level, which is $15. I did note that in one testimony. That was the only difference between what we had filed and what the other witness recommendations were. So there was no update to the numbers, so there's no way to know the difference at this point.
Do you have an estimate of what the differences were at that point?
Well, the end result would always be the same. It's according to whether it shows up in the fixed costs or in the volumetric fees, or in the residential versus the other charges for the commercial and or bulk rates. So again, we'd have to wait to the end to figure all this out. That's not one that's calculable today.
Yeah, no, I understand that that it's just a shifting of the cost.
Yes, that's all it is.
I understand that. Do you or does anyone have an estimate of, with respect to, say, the average customer, how that would affect the average customers, or any estimate of that?
Again, the only change that was recommended was leaving the fixed cost the same, which would still result in the same overall bill being charged to the residential customer on average. It would just be whether it was in the fixed charge versus the volumetric fees. In other words, your volumetric fees would have to capture whatever the fixed fee didn't. So the end result would be the same. That's why I don't think there's any change at this point.
I understand. Thank you very much.
Thank you, Your Honor. If there's no other questions for Mr. Lyons, call our next witness.
Please call your next witness.
The company calls Mr. Dylan DeAscendis. Would the court reporter please swear him in once he is available on Zoom?
you just give me a second to shuffle some papers around.
Morning, sir.
Good morning.
You state your full name, please.
Dylan DeAscendis.
Sir, would you raise your right hand? You solemnly swear the testimony you're about to give will be the truth, the whole truth.
Yes.
Thank you. Mr. Diascendis' testimony is Exhibits 3 and 4. Mr. Diascendis, please state your name and business address for the record.
Yes, my name is Dylan Diascendis, DASCENDIS. I'm a partner at Scott Madden, and my business address is 1820 Chapel Avenue West, Suite 300, Cherry Hill, New Jersey, 08003.
Mr. Diascendis, what is your role at Scott Madden?
I'm a partner there.
And can you briefly describe your responsibilities in that role, please?
Yes, I support financial studies for utilities and municipalities, including cost of capital and valuation services.
Thank you. Did you prepare and cause to be filed testimony in this proceeding?
I did.
Can you please identify the type and date of each testimony that you filed?
Sure. I filed direct testimony on April 4th, 2025, and rebuttal testimony on April 17th, 2026.
Were your testimony and any associated schedules or exhibits prepared by you or under your direction and supervision?
They were.
Do you have any corrections, updates, or clarifications to your testimony as they were filed?
I don't.
If I asked you the same questions today, would your answers be the same?
They would.
Do you adopt your previously filed testimony, including all schedules and exhibits, as your testimony in this hearing?
I do.
Are the schedules and exhibits attached to your testimony the same as those filed in this proceeding?
They are.
To your knowledge, are those schedules and exhibits true and accurate to the best of your knowledge and belief?
Yes.
I have a few more questions for you. In one or two sentences, could you please describe the purpose of an authorized ROE for a regulated utility? I'm sorry, for the court reporter, that's return on equity.
Sure. The authorized ROE is the level of profit a company is allowed to have the opportunity to earn, and the level of that ROE should be sufficient to maintain financial integrity and allow the utility to attract capital on reasonable terms.
And in your opinion, should the ROE be set based on capital market evidence rather than as a tool to reward or penalize the utility for other disputes?
Generally, ROE should be set on market-based models applied to comparable companies.
Thank you. And without repeating your full written testimony, can you please summarize the market-based approaches you use to estimate the cost of equity?
Sure. I applied 3 models. One was the discounted cash flow model, or DC.
I'm going to object, Your Honor. The witness has already submitted testimony. I don't think it's necessary for him to provide a summary again of his testimony.
Well, usually we allow brief summaries. I don't think we need to go in, Mr. Diascendis, to a long discussion of the details, but if you could just give a very brief summary, very brief.
Yes, Your Honor. Again, I applied the DCF model, the capital asset pricing model, which is the CAPM, and the risk premium model to two groups of companies. One was a water group of 5 companies, and the second group, I'm going to speak to my updated group, but the second group was a group of water and natural gas utility companies. And then there was a comparable earnings group that we applied those same 3 models to.
Thank you.
Yep.
Can you briefly state why you use multiple models rather than a single metric?
Sure. It's more about having clarity on or triangulating the appropriate return given multiple models. Not all models have some limiting conditions which can be more or less accurate during different market conditions. So using multiple models gives the analyst more insight into the ROE than just using one model.
Okay, thank you. Just a couple more. DPA's ROE witness relies in part on a double leverage approach. Is that double leverage applicable to Artesian on the facts of this?
I'm going to object again, Your Honor. I think this is really outside the scope of what Direct's meant to be. I mean, these are questions that she can ask him on redirect after in response. But I just think he's getting another bite at the apple, Your Honor.
I'm not sure. I'm not sure I clear. Would you please repeat that?
His direct testimony should be basically a very brief summation of what his testimony is, and then that should be it. He's basically providing testimony in response to the testimony of Mr. Garrett. I mean, that he can save that testimony for redirect, Your Honor.
I agree. You need to limit this, Ms. Emerson. He needs to limit it to the direct.
That's fine. We can do that on redirect. I will turn him over for cross-examination.
Kate Workman on behalf of staff. Mr. Diascendis.
Good morning.
Good morning. Artesian Water Delaware itself is not a publicly traded and does not issue publicly traded common stock. Is that correct?
That's right.
And in your direct testimony, you applied the discounted cash flow, DCF, risk premium model, RPM, and capital asset pricing model, CAPM, to non-price regulated proxy groups. Is that correct?
That's right.
And you deemed those non-price regulated proxy groups comparable in total risk to the water utility proxy groups. Is that correct?
I did, and the selection criteria for that, at least in the direct testimony, is on Exhibit DWD2, Schedule DWD-6. You can see that. I guess it's pages 1 through 6, and it will show my selection criteria for the non-regulated group as compared to the utility proxy groups.
And those non-price regulated companies are not regulated water utilities, correct?
They are not. No, it's actually a part of my selection criteria that they are not utility companies.
And the non-price regulated results in your direct testimony were higher than the water utility results. Is that correct?
From what I recollect, yes, at least in direct. Let me check my rebuttal. Generally, my direct, yes, they're slightly above. And then in my rebuttal, if I'm looking at, if you're looking at Exhibit DWD2R, Schedule DWD2R, page 2. If you're looking at the left column, which is based on the proxy group of 5 water companies, and you'll see on line number 5. Or well, line number 4 has the results of the non-reg group in there. If you look at that as compared to the other models, so you'll see that there's a slight overlap with the capital asset pricing model results, but generally they are higher than the model results applied to the utility companies.
In your rebuttal, you state that the use of the S&P 500 to calculate betas may not accurately reflect utility proxy group risk because of the influence of the Mag 7 stocks. Is that correct?
That's right.
And that means that the choice of market index and beta source can materially impact results. Is that correct?
Yes, but that's basically the judgment of the analyst. Like if you select, say, the use of GDP growth rates for a DCF analysis, or if you use historical growth rates or something other than that. I mean, the ROE analyst, the expert in this, any type of input is subjective and can lead to material differences in results and recommendations, as you can see in the record in this case.
In your rebuttal testimony, you recommend the commission rely solely on projected EPS growth. Is that correct?
That's right.
And projected EPS growth rates are forecasts. Is that correct?
They are.
And forecasted results are not known and measurable. Is that correct?
They are not known and measurable, but when you're looking at things like utility earnings growth, since they are a stable and mature industry, the analysts have more insight into those type of growth rates than, say, in more speculative ventures. Also, as discussed in my in my rebuttal testimony, I've provided significant support in use of or in support of using projected EPS growth rates for the DCF. And I'll just point briefly to where it is, just so we could talk about it, but not. So you could see it starts on page 21 and goes through basically page 29, and it shows that EPS growth rates are supported academically as the preferred and superior measure of growth in the DCF model, whereas Ms. Reno's choice of using a sustainable growth rate or using book value per share or dividends per share growth rates are not supported by academic literature and actually are disproven by empirical evidence.
To the extent that Artesian faces regulatory or compliance risk, the commission can address those risks through rate base, expense recovery, deferrals, or other rate making tools. Is that correct?
I'm not sure. So I can't answer that question. I'm sorry.
No worries. Your direct testimony adds a flotation cost adjustment of 0.17% for the 5 water company proxy group and 0.18% for the 7 water company proxy group. Is that correct?
It does, yes.
And the flotation cost calculation relies on the issuance costs incurred by Artesian Resources Corporation, which is the parent company, correct?
That's right.
You also testify that flotation costs should be recognized even when there has not been a test year issuance and even without an imminent issuance of additional shares. Is that correct?
Yeah, and I'll tell you why on that. So when a company floats stock, that's used to finance long-term capital or plan, right? So if you have costs of that flotation of the notes or of notes as far as that debt financing, and then equity as far as equity financing, the cost to issue that debt or equity is a lost cost, right? So if you had zero flotation costs or zero issuance costs, you would then be able to issue or use those flotation costs to invest in plan. Because you're financing the equity, or you're financing with equity, that equity is outstanding into perpetuity. And because that foregone, those expenses are no longer used to finance the plants, you need to be able to recover it in ROE. So if you have, if you don't have a test year issuance, if you don't have known and measurable issuance, all of that really doesn't matter because the equity that you've already issued is outstanding and still, and the assets that the cost should have financed are still outstanding. So you still need to put those costs into your ROE.
But Artesian Water Delaware itself is not publicly traded and doesn't issue those publicly traded common stocks. Is that correct?
Yes. And now, I mean, the one thing is that
I'm just going to move on to the next question, and you can address whatever you need to address in redirect. Your flotation adjustment is not tied to an actual Artesian Water Delaware common equity issuance during the test year, correct?
it's not during the test year. It would be previous issuances that would need to be recovered from based on what I was saying earlier.
And it's not tied to a known imminent Artesian Water Delaware common equity issuance. Is that correct?
That's right.
I have no further questions.
Sure. Just give me a second. Sir, you have a copy of your rebuttal testimony with you?
I do.
Okay. Looking at page 54 of your rebuttal testimony, you said that Mr. Garrett is wrong when he claims that ARTNA engaged in double leveraging, that is, raising debt at the corporate level and infusing it as equity in operating expenses to earn excess returns. Is that correct?
Yeah, and that's because Artesian Resources doesn't issue debt. So all the debt on the books of Artesian is from the affiliate company. So it's impossible for the company because they did not, the company meaning Artesian Resources, it's impossible to infuse debt as equity financing because they don't have any debt financing to begin with.
But, I mean, aren't they still connected with the subsidiaries though?
No, because I mean, Mr. Spate will be able to answer this because he does the financing for the company. But if you have so the whole thing with double leverage, and I don't agree with double leverage generally, but the theory is that the corporate parent raises debt capital. So say you get it at 4%, and then they infuse it into the operating company as equity and get 10%. Right? If the corporate parent doesn't issue debt, they can't infuse that debt as equity into the operating subsidiary. So there's no way, zero chance, it's impossible for Artesian to be engaging in double leverage. Period.
You're saying it's impossible?
It's impossible.
Okay.
For this company particularly. But you could ask Mr. Spade about it, but it's impossible.
Understood. On page 56 of your rebuttal testimony, you criticize Mr. Garrett's DCF analysis, and you say Mr. Garrett's assumption that one growth rate applies to all companies, even though divided yields vary across those companies, has no basis in theory or practice. Did I read that correctly?
Yes, because when you're looking at, well, no, you didn't read it correctly. I think you said divided yield.
Mispronounced that, sure.
Right, dividend yield. So when you're looking at the DCF, you're looking at company specific growth rates and dividend yields.
Okay, I understand that,
For
but
so for Mr. Garrett to use a generic growth rate based on the long-term growth of the economy as opposed to company-specific growth rates, it's incorrect.
that's your position. But you say that he has no basis in theory or practice. I mean, Mr. Garrett's been testified before the Delaware Public Service Commission and other public service commissions around the country. And I mean, am I wrong to assume that Mr. Garrett's practice is not shared by any other experts in this field?
Yes, but I'll turn you to page 60 of
Okay,
my,
so you answered my question. So your statement here that it has no basis in theory or practice is not correct then.
No, I agree that with my statement. What I'm going to point you to is page 60 of my rebuttal testimony,
Okay.
where this specific piece was brought up in Florida. Okay.
I want to get to that in a question, but so in the Florida case, Mr. Garrett's testimony was rejected, correct?
Well, we could just read it. I'll read what the Florida PSC had to say about Mr. Garrett's GDP growth rate in DCF. It said, witness Garrett's argument to use the GDP growth rate in his DCF model is not supported by persuasive evidence.
Right. I've got that there. Yeah. No. And so, sir, yeah, I understand that. So that was but are you aware of any other public service commissions around the country that have rejected Mr. Garrett's position? I mean, you only cite to one.
I don't think Mr. Garrett's position's been accepted in any jurisdiction as far as I know.
Okay, but you don't cite to any, and your position's probably been rejected in certain jurisdictions as well, correct?
Possibly.
Possibly. I mean, and that's something in terms of litigation with experts. A court or a commission accepts one expert's opinion and rejects another, and it varies depending on the case, correct?
So in the almost 20 years that I've done this, I've never seen a commission use the GDP growth rate as the earnings growth rate or sustainable growth rate at DCF. And I've testified in over 200 cases. Okay. So it is not commonly accepted. It's commonly rejected. The way that he applies this, he's the only person that I've seen, only witness that I've seen use that type of DCF analysis, and it's been rejected every time he's done it.
But just to back up, you only cite to a Florida case.
True.
You don't have a handbook of says these are all the cases that Mr. Garrett's been rejected or approved in, and these are all the cases that I've been. You didn't provide that here.
No.
Okay. But just backing up again, you said that Mr. Garrett's assumptions on page 56 has no basis in theory or practice. There are certainly other individuals in this field that agree with his practice, correct?
No, and nobody else in this case either.
So you're saying no one else?
Miss Reno has not. So if we're talking about the record in this case,
well, I'm not talking necessarily just about the record in this case.
Mr. Garrett's the only person that used GDP growth rates as the sole growth rate in his DCF model. Miss Reno and I do not. Period.
Okay. All right. On page 59 of your testimony, sir, you talk about that there are some basic financial texts that support your position, correct?
So page 59 discusses how the utility industry is in the mature phase of a three-stage DCF, and that is characterized by stable and projected growth rates, stable earnings and dividends, as said runs in the 59 into 60. The conclusion is from lines 8 through.
That's not really my question. My question was that there are some basic texts that support your position, correct?
There are, yes.
Okay. And there are basic texts that support Mr. Garrett and other experts' positions, correct?
I haven't seen any. Can you point to something in Mr. Garrett's testimony that says you got that?
Mr. Garrett's not testifying right now, so.
Well, you just characterized saying that there's support for the growth rates, and then you don't have
this is
support that's shown there.
what,
So you just
Let him finish. This is
yes, Your Honor.
This is an important point. Please proceed.
so if you could point to where Mr. Garrett provides any type of text support for his sole GDP growth rate in his DCF, which I don't remember seeing in his testimony, please show it.
Okay, well, we'll deal with that with Mr. Garrett. And then finally, sir, I think finally, on the issue of size premium, which is on page 69 of your testimony. You there, sir?
I'm getting there, yes, sir. Go for
Take
it.
your time.
I'm there.
Okay. And just so I understand, there's another disagreement between Mr. Garrett and yourself. He focuses only on returns and you do not, correct?
I'm going to try and clarify that question.
Okay.
So Mr. Garrett in his testimony, and you could correct me if I'm wrong, he says that there is no evidence of the size premium, which is a return premium. So that means that so previous to 1983, small companies had higher returns than larger companies. Mr. Garrett testifies that after 1983, the return premium, so large companies returned higher than small companies. My testimony says that return is not a measure of risk. Risk is a measure of risk. So when you go into page 70, if it's starting on lines 11 and runs through 71, my position is that the standard deviation of returns is what is risk. So while the returns may not have, while small companies didn't return higher, the standard deviation of those returns, which is risk, is higher for smaller companies than larger companies.
Okay. And then, sir, I just had a question or two, clarification on the Kroll in terms of the data. Can you explain why they continue to publish this data?
Well, they must still think that there's, they must still believe that there's risk between, increased risk for small companies over large companies. I don't work for Kroll, so I wouldn't know.
Okay, so you don't know specifically. You just know that they continue to publish this data, but you're not aware of a reason that they've said this is why we keep on publishing this data.
They do not say anything on that, so I would be speculating.
Okay. Okay. Thank you. Those are all my questions at this time, sir.
All right. Thank you.
You may redirect, Ms. Emerson.
Yes, I do, Your Honor. Could you please refer back to your rebuttal testimony on page 60? You were asked regarding the position taken by Florida on Mr. Garrett's GDP growth rate position. Could you please complete your thought on that, including the reference to the lines 19 to 23?
Yeah, I was just going to read it into the record. I mean, it's already here, but the Florida Commission says, as far as the GDP growth rate in a DCF analysis, witness Garrett's argument to use the GDP growth rate in his DCF model is not supported by persuasive evidence. We agree with witness DeSantis that the growth rate should reflect a measure of the utility's individual growth and not a generic measure of the output of the entire economy.
Thank you. Did you have additional information that you wanted to provide regarding the flotation costs? I know you were invited to do that on redirect, so I just wanted to provide you that opportunity.
Yeah, so I have something as far as let me go here. But in my rebuttal testimony, I talk about flotation costs, and it's on page 39 of my rebuttal. Wholly owned subsidiaries such as Artesian Water Company, they receive capital from their parents, right? Which is only going to be equity because, as we established, debt is not issued at the parent company level. Because that equity that is being infused into Artesian Water Company, they have those flotation costs rolled into those equity infusions. Because of that, the constituent parts or the operating subsidiaries of Artesian Resources would be responsible to recover those flotation costs in rates.
With regard to staff's proposal for an imputed capital structure, then, from a cost of equity standpoint, does selecting a hypothetical structure change what investors require?
It's not what it changes what investors require. It's just doesn't reflect the cost of capital of the company. So if the companies.
Your Honor, I'm going to object to this question. It's outside the scope of the cross-examination. I didn't ask him any questions about capital structure.
Ms. Emerson, that seems reasonable to me.
That's fine. We have no further questions.
Any recross?
No recross, Your Honor.
No recross from staff.
Now I'm going to ask the question that I forebode. Mr. Please, DeSantis.
Yeah, DeSantis.
Do you have your calculator there? Can you tell me approximately what the revenue differential is for the overall revenue requirement requested by applicant between your ROI that you've recommended and either Ms. Hall's or the ROI of Mr. Garrett? Do you have that number, or do you have an approximation? I saw a couple of points of the testimony that it's that the issue of ROI is a large issue, and the numbers are large. Am I correct on that? Do you have can you punch your computer and tell me the number?
I cannot, Your Honor. I generally just work in percents, not dollars. Just because sometimes those numbers get big, and I get nervous when the numbers get big. But I know I think the revenue requirement person should be able to get you the differences in each contested piece. So ROE, obviously, there's a difference between the overall cost of capital versus staffs and the consumer advocates. The public advocates, I'm sorry. There should be somebody that can give you the answer. I do not have the answer for you. I would expect that the revenue requirements person would have it, whoever that may be.
Ms. Emerson, do you think that's possible? Approximation.
Sorry to put you guys on the spot.
I'll give you a few minutes. And anytime you have the number, please let me know.
Will do.
Unless you're about to get it.
Probably give you as close as you can at this point in the case,
Please speak into the microphone.
obviously the situation surrounds rate base, et cetera, and what a return might be.
Understand.
But if you make basic assumptions from the DPA 7.4 to our case of 10.6, that's nearly it's over $8 million. That's quite a large differential. If you go just to where we're at today, the 9.5, that's worth about $5+ million.
I'm sorry, say the last thing again, please.
If you go from the 7.4 to what we are allowed today, which is 9.5%, that differential is about $5.7 million. In other words, if you reduce what we're currently allowed to the recommended 7.4, you're looking at about about $5.5 to $5.7 million in revenues.
Do you have the number between what you're asking, what you're recommending in this case to your current ROI?
That would be about $3 million.
3 million, less than, so you're approximately $10 million revenue. That would reduce your revenue to 7 million, approximately.
Yes.
Your Honor, if I may, I had
Mr. Crumpler.
I had a communication with Mr. Watkins, and he said he'll be able to provide that calculation on the
Good.
stand. Just
I promised I would ask each person.
And I am just using estimates because
I get that.
rate base and everything else gets involved with that. So
The capital structure, rate based, other things.
well, the capital structure is completely separate, and I can give you an approximation on those too as well.
Okay, when the time comes.
And on the that was DPA on staff. The difference,
9.03, I think, or something like that.
yeah, 905 was their
905.
case. Let me just get to that, or 902 was between our case as filed 4.3 million between the 9.5 and the 902 is about again, I'm guessing now about 1.4 million in that area, just on the ROE change, not anything to do with the capital structure. And again, I'm estimating.
That's a fair comment. I was just trying to figure out whether this thing was bigger than a bread box or smaller than an elephant. I mean, and because the difference on revenues numbers here are elephant size.
Yeah, DPA has the largest disparity. Staff is less.
That's what I'm trying to understand. Thank you very much. Ms. Emerson.
Used.
All right, thank you.
Artesian would like to call its next witness, Michael Christopher. Michael is present with us here. So. Yeah.
Your Honor, can we take a brief break?
Sorry, please.
Can we take a brief break?
We sure can. We'll take a break, be back in 10 minutes. Before we go further, we're back on the record. I would like to follow up the questions that I asked a couple minutes ago to Mr. Spate, because I didn't get the numbers quite right. So let me try to ask the questions a little more carefully so that I get the numbers right. Mr. Spate, with respect to the ROE, your current request in the testimony is an ROE of about 10.6. If the ROE were what you received currently, which is 9.05, strike that 9.50, what would that reduce your revenue number? $3 million. And if you went to the 9.02, I believe it is recommended by staff, what would that reduce it further?
Additional 1.3 million.
An additional 1.3, so the total would be 4.3. And I've got your number for the staff, for the DPA. Thank you. Ms. Emerson.
Your Honor, we would like to call Mr. Christopher as our next witness. I do have a procedural question for the record. For witness Hall, there was several late descriptions submitted or changes to Ms. Hall's testimony. Those would impact the, I suppose, testimony cross-examination of Mr. Christopher. Would you like those to be reflected on the record at this point, or would you like to proceed with cross-examination and then address those on Ms. Hall's testimony?
Ms. Emerson, I'm sorry. I didn't hear your word
That's
speaking.
fine.
I have two problems. Number one, you weren't quite speaking into the record. Secondly, I don't hear that well. So could you please tell me again, please?
For witness Hall, who will be later today or tomorrow, there were several modifications to her testimony that were submitted of late, and those would impact likely the examination, cross-examination of Mr. Christopher and some of the adjustments that he would be testifying about. Would you like those modifications to be entered into the record at this point, or would you like to reserve those until Ms. Hall testifies?
Explain to me Ms. Hall's testimony. You say she's coming tomorrow, is that right?
Or today?
Your Honor, she's one of staff's witnesses, and she has a couple corrections to her testimony to make, but those corrections would likely impact the current testimony. So we're trying to ask, when should we introduce those corrections?
Well, let me ask, it's Ms. Hall's corrections, right? When would you like to have them, Ms. Emerson?
Is Ms. Hall here? Would you like to put her on briefly just for the purpose of introducing those corrections?
I would prefer to have it all done at one time, but I'm trying to be sensitive to the situation.
Ms. Hall is not ready for that, Your Honor.
Let's defer it.
Okay, thank you.
Sorry.
So could we have the court reporter please swear in Michael Christopher? Morning, Mr. Christopher. Could you please state your name and business address for the record?
My name is Michael Christopher. My business address is 664 Churchman's Road, Newark, Delaware, 19702.
By whom are you employed and in what capacity?
I am employed by Artesian Water Company, and I am the rates analyst.
Could you please briefly describe your responsibilities in that role?
I evaluate the company's rate structures and ensure regulatory compliance and also assist with the rate cases.
And did you prepare and cause to be filed testimony in this proceeding?
I did.
Can you please identify the type and date of each testimony that you filed?
Yes. I filed direct testimony on April 4th, 2025, supplemental testimony on May 23rd, 2025, a final supplemental testimony on December 1st, 2025, and rebuttal testimony on April 17th, 2026.
And those are at exhibits 5, 6, 7, 8.
Correct.
Were your testimony and any associated schedules or exhibits prepared by you or under your direction and supervision?
They were.
Do you have any corrections, updates, or clarifications to your testimony as filed?
I do not.
And if I asked you the same questions today, would your answers be the same?
Yes.
Do you adopt your previously filed testimony, including all schedules and exhibits, as your testimony in this hearing?
I do.
Are the schedules and exhibits attached to your testimony the same as those filed in this proceeding?
Yes.
And to your knowledge, are those schedules and exhibits true and accurate to the best of your knowledge and belief?
Yes, they are.
Mr. Christopher is available for cross-examination.
Your Honor, Stephen Ferguson for staff. May I proceed?
Sorry, please.
Stephen Ferguson for staff. May I proceed?
Please.
Good morning, Mr. Christopher. Do you have your rebuttal testimony in front of you?
Give me a second. Yes, go ahead.
Can you turn to page 2, please?
Got it.
Do you see there that you describe Catholic Charities as serving as a third-party administrator of
Yes.
a customer assistance program for income qualified artesian customers? Is that correct?
Yes, I do see that.
And you further testify on the same page that Catholic Charities performs defined administrative functions, including eligibility screening and program administration. Is that correct?
Yes, I see that.
And screening means that Catholic Charities applies criteria and admits some applicants while turning away others. Is that correct?
I'm not sure if they turn people away, but
The phrase income qualified, that ordinarily means a recipient has been measured against some income standard and found to qualify, correct?
for income qualified, I don't necessarily think it means a salary or compensation that they receive. I think it's more of like a financial hardship.
And so, in terms of financial hardship, that would require some sort of measuring stick, some level of income or hardship that the program treats as qualifying. Is that correct?
Yes.
If you could turn to one of the documents I passed out prior to your cross-examination, it's PSCR 1.7C, and just let me know when you have that.
Go ahead.
Your Honor, do you have the document?
I do.
In response to PSCR 1.7C, the company stated there are no specific income eligibility requirements. That's correct?
That's correct.
So there is no income threshold of any kind that an applicant must meet, correct?
As far as I know, no.
So the same program the company concedes has no specific income eligibility requirements is the one your testimony calls a program for income qualified customers with eligibility screening. Can you clarify which of those is correct?
Yes. So as I mentioned, the income qualified portion of my rebuttal testimony, I would say is more so leaning towards people having hardship, not necessarily their actual income.
If no applicant must meet any income requirement, then no applicant can be screened out for income. That's correct.
Yes, that's correct.
You could put that document aside, and could you please turn to PSC-R-4.8, please?
Go ahead.
So before we get to that, just turning back to the last questions, you testified that the criteria is financial hardship. What is the criteria for financial hardship?
I can't speak to the actual criteria necessarily, but I know it's not income based. It's essentially when our customers are experiencing some kind of hardship where they have arrearages to keep their water on. So that's why we started that program, to keep our customers' water on.
So I'm sorry, do you have PSC R-4.8 in front of you?
I do.
So in that data request, staff asked the company to reconcile the contradiction that we just discussed. And in response, the company pointed to the document that's attached to PSCR 1.5 for its guidelines and documentation requirements. Is that correct?
Yes, that's correct.
And if you could turn to that attachment to PSC R 1.5 that you should also be provided. Okay. And under the heading, do you see under the heading, there's Artesian Water Crisis Alleviation Program?
Yes.
And that document states in the program guidelines, there is no income guideline for this program. The program is available to anyone in temporary crisis. Is that correct?
Yes, that's what it says.
So the document the company relies on to prove eligibility screening states in its own words that there is no income guideline and that the program is open to anyone in temporary crisis. Is that correct?
That's what it says.
Your Honor, may I ask a housekeeping note? Your Honor,
Right.
just a housekeeping note. So I'd like to introduce these discovery responses into evidence. This is the first time we're doing it in this proceeding. Would you like me to do them all at the end? I could do some piecemeal right now. What is Your Honor's preference?
Well, let me ask, it seems to me that maybe you would do it one at a time. Does that make sense?
Sure.
Mr. Crumpler?
Whatever Your Honor thinks is fine. I mean, I don't have any preference if you want us to do it each document.
I think I would prefer to do that, Ms. Emerson.
That is fine with us. Thank you.
Let's do that.
So, Your Honor, I'd like to move into evidence. I believe it would be Exhibit 26, the company's response to PSC-R-1.7C.
Are there objections?
None from the DPA, Your Honor, but
Ms. Emerson?
None. Thank you.
With no objections, moved into the record.
Next, Your Honor, I'd like to move in as Exhibit 27, the company's response to PSC-R-4.8.
Are there objections? Mr. Crumpler?
no objections, Your Honor.
Emerson?
None. Thank you.
And moved into the record, please. What number did you say?
That was Exhibit number 27.
27, thank you.
And lastly, at this time, Your Honor, I'd like to move in as Exhibit 28, the company's response to PSC-R-1.5, including the attachment that was provided along with that response.
Objection. Mr. Crumpler?
No objection, Your Honor.
Ms. Emerson?
No objection.
And moved into the record as Exhibit 28? Is that correct? 28?
That's correct, Your Honor.
Thank you.
Mr. Christopher, are you ready to resume?
Yes.
So turning back to the financial hardship of the customer, is there any written definition of what constitutes a financial hardship?
I'm not necessarily familiar with any exact language of a financial hardship, no.
Okay, thank you. Could you please turn to the company's response to PSC-R-1.6 and let me know when you're there?
Go ahead.
In response to that request, the company stated that Ms. Hall's testimony incorrectly described the funds provided to Catholic Charities to be a charitable contribution, which would be discretionary. However, the expense is related to the provision of financial assistance to customers in financial need, and which is a benefit to customers that the Commission has specifically approved in every Artesian base rate case. Did I read that correctly?
You did.
You can now turn to the company's response to PSC-R-4.7, please.
Okay.
In that data request, the company was asked to provide a reference to order number 10460 in docket number 23-0601 that the company asserts specifically approved the Catholic Charities costs. Is that correct?
Yes.
And in response, the company referenced the response to DPA-5.0. Is that correct?
5.10.
0.10,
Yep.
excuse me.
Yes.
0. Can you turn to DPA-5.10, please?
Okay.
Can you please tell me where in DPA 5.10 the company provides a reference to order number 10460 in docket number 23 06001 that the company asserts specifically approved the Catholic Charities costs?
There isn't any.
So the company is not aware of any commission order that authorizes, directs, or requires this expense, correct?
Not in the 23 case, no, but in 14, the Catholic Charities related expense was essentially in that case, and no parties chose to make any sort of adjustment to that.
So because the expenses were not contested by a party in docket number 14-132, the company considers that the equivalent of the commission specifically approving these costs for every rate case?
I'm sorry, could you repeat that?
Sure. So because these expenses were not contested by a party in docket number 14-132, the company considers that the equivalent of the commission specifically approving these costs for every rate case?
I would say not necessarily equivalent, but considering neither party chose to do anything with it in the 14 case, we decided to continue the program to help customers.
But is that the same as the commission specifically approving these costs for every rate case?
Not specifically approving, no.
These costs were contested in docket number 23-0601, correct?
They were, yes.
Your Honor, I'd like to move in as Exhibit 29, the company's response to PSC-R-1.6.
Mr. Crumpler, objections?
No objections, Your Honor.
Ms. Emerson?
No objection, Your Honor.
Without objection, so moved.
Thank you, Your Honor. I'd like to move into evidence as Exhibit 30, the company's response to PSC-R-4.7.
As Exhibit
30, please.
30. Mr. Crumpler?
No objections, Your Honor.
Ms. Emerson?
No objections.
Without objection, so moved.
And lastly, at this time, Your Honor, I'd like to move in DPA rebuttal discovery DPA-5.10 into evidence as Exhibit 31.
Without objection, Mr. Crumpler?
No objections, Your Honor.
No objections.
Without objection, so moved as Exhibit 31.
1 second, Your Honor. Mr. Christopher, are you ready to proceed?
Yes.
So we're going to shift gears a little bit. Artesian's common stock is listed and traded on the NASDAQ exchange, correct?
Yes.
The company is seeking recovery of the fees related to the listing on the NASDAQ, correct?
That's correct.
Can you please turn to the company's response to staff rebuttal data request PSC-R-4.1?
Okay, go ahead.
In that response, the company clarified that it originally included the entire $56,000 amount of the NASDAQ listing fee in its filing, but subsequently modified that to $49,530 to represent Artesian Water Company's allocated portion. Is that correct?
Yes, that's correct.
Your Honor, I'd like to move into evidence as Exhibit 32, the company's response to PSC-R-4.1.
Crumpler?
Steve, what was the date on that document?
I believe
May 21st.
Okay, I just want to make sure that I'm not later on introducing the same thing. No objections, Your Honor.
He said no.
No objections, Your Honor.
Look into exhibit as exhibit number
32. You can put that document aside. If you could turn to your rebuttal testimony, please, at page 7. Let me know when you're there.
Go ahead.
You ready?
Yep.
So you state there, the NASDAQ fee is a mandatory and non-discretionary expense incurred to maintain the company's public listing status, which is integral to its ability to access capital markets, comply with security regulations, and finance utility infrastructure necessary to serve customers. Did I read that correctly?
You did.
The company is also seeking recovery of charges from OTC Markets Group. Is that correct?
That's correct.
The amount of these costs that is being sought for recovery is $15,000, $15,740. Is that correct?
Yes, that's correct.
Were the full amount of these charges, excuse me, let me start over. Were the full amount of these costs charged to Artesian Water Company as the NASDAQ charges originally were, or just Artesian Water Company's allocated portion?
I am not sure.
Do you know what company witness, if any, would be able to answer that question?
Uh, I believe Dave probably could answer that. Dave Spate.
What services did OTC Markets Group provide that are reflected in the $15,740 the company seeks to recover?
I am not sure.
Given that Artesian's common stock is already listed and traded on the NASDAQ, why does the company also require the services provided by OTC Markets Group?
Like I said, I think Dave Spade could speak to the OTC Markets Group questions.
I'd now like to turn your attention to the Pennsylvania Institute of Certified Public Accountants costs that are included within the Social and Service Club dues expense. What do these costs represent?
I believe they are membership fees for the CPA exams that are taken for Pennsylvania.
Do you know whose membership dues these are?
Not off the top of my head, no.
Is membership in the Pennsylvania Institute of Certified Public Accountants required for these individuals at Artesian to perform their jobs?
I don't want to speak to anyone else's job qualifications or requirements.
Is a membership in the Pennsylvania Institute of Certified Public Accountants required to maintain a CPA license?
I'm not a CPA. I don't know.
How did the company determine that this was a necessary cost to recover from ratepayers?
Just the Pennsylvania CPA. That's what you're talking about. That's what
Yeah.
you're referring to.
Yes, what we were just discussing.
I do not have an answer for that one.
If we could now turn to the FMLA leave manager costs that are listed in the social and service club dues. Can you explain what these costs are?
I cannot speak to the exact cost.
What company witness should these questions be directed to?
I would direct them towards Dave Spade.
Thank you. No further questions.
Mr. Crumpler.
Mr. Christopher, you good to continue, or do you need a break, or?
No, we can keep going.
Um,
Into the microphone a little more
Yep,
carefully.
my apologies, Your Honor. Okay. Sir, you've got a copy of your rebuttal testimony, correct?
I do.
And Mr. Ferguson was asking you some questions about Catholic Charities, and I've got some follow-up questions about that. On page 2 of your testimony, you say Catholic Charities performs defined administrative functions, including eligibility screening and program administration, that enable the company to provide structured bill assistance to customers experiencing financial hardship. Is that correct?
Yes.
Okay. And sir, I handed you earlier a document that's entitled Responses to Fourth Set of Data Requests. And it's dated on the last page, October 17th of 2025.
Yes, I have that.
Okay. I know there's a lot of paper around here, so I just want to make sure. And on page 2 of the document, under the responses, 904,000, it says Catholic Charities is a resource for customers to contact to help pay their water bills. The company reimburses Catholic Charities for the amount provided to customers to pay their past due water bills. That's correct?
Yes, that's what it says.
And one second. At this time, I'd like the document, which is labeled responses to fourth set of data requests, dated October 17th, 2025, into the record. And I apologize, I forget what exhibit we're up to. 33, Your Honor.
Okay. Ms. Emerson, do you have any objections to that?
I do not.
No objection, Your Honor.
Moved into the record as exhibit number
33, Your Honor.
3.
Mr. Crumpler, what was the name of that exhibit?
It's entitled Responses to Fourth Set of Data Requests, PSC 4.1, and it's dated October 17th, 2025.
Thank you.
Sure. Right. Give me a second. All right. Okay. Sorry, 1 second, sir. Sorry. Okay. And then on page, do you have your rebuttal testimony?
Yes.
Okay. And you comment that on the middle of the page, to the question, did the company remove this expense from its rate model? You said, yes, the company removed the charitable donations from its model and its 9+3 filing that was submitted on August 29th, 2025. Specifically, this adjustment was made by DBS Exhibit 1, Schedule 3B, Page 1, where the amount previously listed was $64,495 was removed. That's correct?
Yeah, that's correct. Are we done with the Catholic Charities fourth?
Oh, yes, my apologies, sir. Yes, we are done with that document for now. Okay. And then just a few more questions on the Catholic Charities questions.
Your Honor, we'll need clarification on that because witness Christopher just asked if we were done with Catholic Charities, so I think.
No, he asked if we were done with the previous document. That's what I.
Well, he said with the Catholic Charities, so I think the confusion
Oh.
there was what the scope of the charitable donations meant. So he was answering your question based on.
My apologies.
I'd moved on from Catholic Charities.
I'm not done yet. I will try and keep things moving along, though. Okay. All right. And, sir, I handed you previously what's marked as responses to DPA's second set of data requests, and it's dated December 19th, 2025.
Yes, I have that.
Okay. And okay. And is this the document where the scheduled Catholic Charities was removed?
I'm sorry, can you rephrase that question?
Sorry, was this document demonstrate that the Catholic Charities, I guess, donation was removed?
No, the Catholic Charities was not removed because it's not a charitable donation.
Asked that this document be introduced as we're up to what, exhibit number 34?
34.
Okay. Okay.
Mr. Crumpler, what's the name of that document?
Sure, Ms. Workman, it's PSE docket number 25-0346, responses to DPA's second set of data requests, and it's from December 19th, 2025. Okay. That on the floor. All right. Sir, now, you sort of touched on this a little while ago, but just for a clarification, do you know if Artesian has a commission-improved low-income assistance program that requires ratepayers to fund such a low-income assistance program?
I would say it's not specifically approved. No.
And do you know if Artesian is required by the commission to provide low-income assistance?
No, I don't know.
All right. And it's shifting gears a little bit. Looking back at your rebuttal testimony, sir. Okay. And sorry, give me 1 second. On the bottom of pages 5 and 6, you talk about social service club dues, correct?
Yes, that's correct.
Okay. And do you have a copy of Mr. Watkins' GAW 13?
Probably you're gonna have to give me a minute.
Take a moment. If not, I can hand you my copy.
Excuse me, that was Mr. Watkins. What?
It's Mr. Watkins' GAW 13. It's part of his overall exhibit.
GAW 13.
Yes, sir. Yeah, okay.
Good.
And just looking over that, it appears that Mr. Watkins has allowed for memberships in professional organizations, correct?
Yes.
Okay. But he hasn't allowed for membership in the Chamber of Commerce, contractor associations, leadership alliances, and similar organizations.
That's correct.
You can put that document off to the side for a second. The next document that I'd like you to look at was a web printout from the Newcastle County Chamber of Commerce.
Yes, I have it.
Okay. Give me a second too. Okay, sorry about that. Looking specifically at the member benefits, education events, and advocacy, can you tell me how these activities directly help ratepayers?
I think Dave Spate would probably be the better person to ask for that one.
Okay. Okay. At this time, I'd ask that this document be entered into the record as exhibit, I think we're at 34,
35.
35. That's why Steve
35.
with us.
Does the court reporter have a copy of that document?
She should. If she doesn't, I will make sure she gets one.
Thank you.
Your Honor, there's no basis for this document. There's not a URL or a date or anything. I don't know where it came from.
I mean, I can clarify. I can find where it came from, but it came from the Newcastle County Chamber of Commerce website.
You're testifying that it came from the Chamber of Commerce website?
Yeah, it was provided by one of our consultants, Your Honor.
Ms. Emerson?
I will leave it up to Your Honor, but there was no foundational basis for this. I understand that we're going to continue testimony on it, perhaps under Mr. Spake, but
We'll leave it in for what it's worth.
Mr. Crumpler, what's the name of that document?
It's, I mean, you can label it how you wish, Miss Workman. But it says Newcastle County Chamber of Commerce. Yeah. Description, I guess. Okay. All right, sir, and I'm trying to speed things along. I know you've been answering a lot of questions. I provided you two large documents earlier. Do you have those, sir?
Yes, I do.
Okay. All right. And one of them is the hearing examiner's findings and recommendations from June 2nd, 2015.
Yes.
Okay. And the other document is the findings and opinions in order from the commission, and that's dated January 19th of 2016. You have both of those?
Yes, I have both.
Okay. All right. And looking at the hearing examiner's findings, looking at specifically page 67.
I'm there.
Okay. And there's a list of organizations that he has disallowed, correct?
Yes, that's what it says.
And several of them appear to be Chamber of Commerce organizations.
Yes, there's a few.
And then looking at the hearing, or sorry, the commission's opinion, looking at page 96. Okay. And looking at paragraph 245. Let me know when you're there.
I'm there.
One I'm seeing has page numbers on it. This is the, excuse me, the findings and opinions, docket 14-132.
Yes, Your Honor.
And what's the reference here?
I was referring to page 96 of the actual opinion, Your Honor.
Thank you.
The numbers are at the bottom. There's a table of contents and everything. And I'm looking specifically at paragraph 245. Okay. And here the commission says, since no party exhibited to the hearing examiner's conclusions that a portion of the social and professional dues related to lobbying, public relations, and or marketing efforts should not be recovered in rates, we will not disturb that conclusion that the company is allowed to recover $110,154 in social and professional dues in this rate. Is that correct? Did I read that correctly?
Yes, you did.
Okay. And then shifting gears slightly, back to your rebuttal testimony, sir. Okay. Let me know when you've got it.
Yep.
Make sure I've got it. You state that the companies agreed to a test period pro forma property tax expense of $3,963,948, correct?
Yes.
Okay. And this is what Mr. Watkins agreed with in his GAW 15, correct?
I
If you've
believe so.
and so the company's in agreement with Mr. Watkins on that?
Yes.
Those are all my questions at this time. Oh, and I think I failed to move into the hearing examiner's recommendations and the commission's findings.
The two documents.
The two documents.
Two voluminous documents?
Yes, Your Honor.
Is there objection? Mr. Ferguson?
Objection from staff.
And they're moved into the record as exhibit 35, are we? 36?
36 and 37.
37. Thank you, Mr. Ferguson.
Your Honor, the company has a few more questions. Mr. Christopher. Regarding Catholic Charities, to clarify I think it's number 28. It's the 1.5, the one that has Catholic Charities letter attached to it.
I have it.
In the paragraph below, proposed Artesian water program, it says Artesian customers who are
Could you please speak into the microphone?
It says that Artesian customers who are having financial difficulties, is that correct?
Yes.
So a financial difficulty is more than a low income. Is that
Yes.
understanding?
Yes.
So could perhaps a bad medical situation be a financial difficulty?
Yes.
Could just any general inability to pay your water bill be a difficulty?
Yes.
Or if the person was unable to pay their water bill, i.e. their debt to the company, and just didn't pay, what would Artesian do to somebody who doesn't pay their water bill?
Eventually, they would be shut off.
And then when they're shut off, if they still don't pay their water bill because of financial difficulties, then would we write that debt off?
Yes.
And if that debt is written off, does it then impact the expenses of the company?
Yes.
Um, Moving to the 230601 case, that was resolved by a settlement order. Is that correct?
That's correct.
So did the commission have to rule on every single issue in that case?
No.
And in that case, did the commission specifically disallow the Catholic Charities expense?
No.
The company has no further questions for Mr. Christopher.
No further cross from staff.
No further questions.
Mr. Christopher may be excused.
Mr. Christopher is excused. There are no further questions. Thank you, Mr. Christopher.
Thank you.
For purposes of testifying, he has to stay here.
He's not allowed to leave?
No. Yes, please. Yes. Right. The company would like to call its next witness, Mr. Daniel Konstansky.
It's the point of clarification. What's the kind of the break schedule?
I was going to ask you the same question.
I'm not in charge, Your Honor.
Off the record, please. But we're going to talk about lunch.
Testimony on April 4th, 2025. I provided supplemental testimony on December 1st, 2025, and rebuttal testimony on April 17th, 2026.
To clarify, do you have supplemental testimony dated May 23rd, 25 at Exhibit
Yes, I do.
and final supplemental testimony at December 1st, 2025 at Exhibit 11?
That is correct.
Thank you. Were your testimony and any associated schedules or exhibits prepared by you or under your direction and supervision?
Yes,
Do you have any corrections, updates, or clarifications to your testimony as filed?
I do not.
And if I asked you the same questions today, would your answers be the same?
Yes,
Do you adopt your previously filed testimony, including all schedules and exhibits, as your testimony in this hearing?
yes,
Are the schedules and exhibits attached to your testimony the same as those filed in this proceeding?
yes,
And to your knowledge, are those schedules and exhibits true and accurate to the best of your knowledge and belief?
yes.
Mr. Konstansky is available for cross-examination.
Your Honor, may I proceed?
Ms. Ferguson.
Thank you. Good morning, Mr. Kostansky.
Good morning or afternoon, whichever it is now.
You are the sponsor of the company's testimony related to Filter Media, correct?
Yes,
And you sponsored the company's discovery responses related to Filter Media, correct?
yes.
Could you please turn to company work paper DBSWP-3B-4 and let me know when you're there? I provided you with a copy as well. You can use the binder if you'd prefer.
Yours is right here. That'll be much easier. Yes, I've got it in front of me.
And I'll represent that a final supplemental version of this document was submitted by the company on December 1st, 2025. Are you familiar with this document?
Yes,
This work paper is referenced in your testimony, correct?
correct.
So turning to the actual work paper, if you could turn to the second page, please.
Yes, I have it in front of me.
Do you see at the bottom right-hand corner of the document, there's a proposed annual amount of 1,602,528.93? Do you see that?
Yes,
And that number is the average of the 4,807,586.80 directly above it. That is projected for 3-year costs to be that number divided by 3 to get the bottom number. Is that correct?
yes,
And those are projected costs for change out the company forecast will occur within 3 years. Is that correct?
yes.
What is meant by the phrase within 3 years?
So what's meant by that is it is our best estimate in terms of what we believe will be the number of filter media beds that require change out over that time frame.
When does the 3-year period begin and when does it end?
So the 3-year period begins. In this case, it was, I believe, at the beginning of the test period and then projected out from there for 3 years beyond that.
So it begins at the beginning of the test period in this case. Is that your testimony?
Yes.
So some of the costs were incurred in the test period, correct?
So there were some costs that were incurred in the test period, and then some that were incurred directly after the test period. The estimates for what was going to be changed out within the test period were updated as we progressed through the case.
So just to confirm, the 4.8 million figure we're talking about on this work paper, that includes costs that were incurred within the test period. Is that correct?
It doesn't. The work paper here does not include the exact dates that these were incurred, but yes, my understanding is that there were costs that were incurred during the test period.
Do you know the level of costs that were included in this figure that would have been incurred in the test period?
Not off the top of my head, no. I would need to go back and review.
Is there another company witness that would be able to answer that question?
Mr. Spate would probably be able to answer it. I could also review it, but no.
So just to clarify, the $4.8 million figure we've been discussing, a portion of that is estimated and a portion of that was incurred in the test period. Is that correct?
Correct. Yes.
Who from the testimony can provide that breakdown?
Mr. Spate can most likely provide that breakdown.
Thank you. If you could turn to the first page of that work paper.
The one with the red words and
Correct.
such? Yes.
List 17 facilities, is that correct?
I believe that that is correct. Yes.
The company marks 2 with double asterisks, and that denotes prediction with no data yet, and 8
Right.
more with a single asterisk that denotes prediction with limited data. Is that correct?
That is correct.
So the company has flagged 10 of the 17 entries in the work paper as predictions made with no or limited data. Is that correct?
That is correct. Yes. Based on the timing on which the facility was installed.
11 of the 17 facilities also reflect revisions to the changeout schedule from the original filing to the current work paper, with the revisions ranging from 1 to 22 months. Is that correct?
That is correct.
The largest revisions, 22 months at each facility, apply to the same 2 facilities the company marks prediction with no data yet, and that's Eastern States and Middle Run. Is that correct?
Yes, that is correct because those were the most recent facilities to be brought online. And so therefore there was not historical operational data available because of how recently they had been installed.
We're going to come back to this document, but you could just put it aside for now.
Very good.
Turn to your rebuttal testimony. Now,
Give me just a moment to find it here. Yes, got it.
okay, so I don't believe your rebuttal testimony has page numbers. Is that correct?
According to Exhibit 12? Yes, I'm in Volume 2. My Exhibit 12 in Volume 2 is an Excel spreadsheet. So I'm not seeing my... DWK Exhibit 12? Right, which volume? Right here, Exhibit 12. Ah, got it. Yes, thank you.
We're just looking for your rebuttal testimony, correct?
Yes, I've got it. Thank you.
There's no page numbers, correct?
There are no page numbers, correct.
So I want to make sure we're talking about the same page.
Just clarification, sorry, Mr. Ferguson. I numbered his pages as well. I didn't count the cover page. Did you?
Could you please speak into the microphone?
Sorry. What Mr. Ferguson was just commenting on is that there's not page numbers on his rebuttal testimony. For my questions for him, I wrote down on his rebuttal testimony page numbers excluding the cover page, but I wasn't.
Yeah, that's where I was going. So to make sure we're looking at the same page, I counted them as well, same as Mr. Crumpler. I did not include the cover page. So with that convention, can you turn to page 19 of your rebuttal testimony, and then we'll make sure
Yep.
that we're looking at the same page. And if it is the same page, there's most of the page is taken up by a long answer, followed by question, how does Artesian determine when filter media should be changed out? Are we on the
Yes,
same-
I see the exact page you're referencing.
So on that page of your rebuttal testimony, you state that the filter media expense is known and measurable, notwithstanding minor shifts in the exact date of a particular changeout. The word notwithstanding acknowledges that the exact date of an individual changeout can vary, correct?
That is correct. There are a variety of factors that can influence when a filter media bed is changed out. So yes.
And when the timing of a changeout shifts, the cost of that changeout also shifts with it into a different month, quarter, or year, correct?
Correct. It shifts based on the actual date of the change out.
So now if you could look at page 18 of your rebuttal testimony.
So I have that as the first question on it being, what is the fundamental operational issue that makes filter media replacement timing difficult to predict with precision?
That's correct, and I'm going to ask you about that answer.
Mhm.
So in that answer, you note you note several variables driving the timing that we just discussed,
Mhm.
including raw water quality, contaminant loading, treatment flow volumes, seasonal water temperature, media quality, bed settlement, operational practices, and source performance. Is that correct?
That is correct.
As we're sitting here today, the company does not know what the actual values of those variables will be in the future, such as in the next 3 years. Is that correct?
We can't say what one is going to be exactly, but we can make predictions based on past experience, past data, similar filter vessels of comparable size, etc.
But it wouldn't know the exact value of those variables in the
No,
future.
it isn't possible to know the exact values of each and every one of those parameters ahead of time. No.
So now if we can flip forward page again and go back to 19, please.
Yes.
And I'm in the same area of the answer that we discussed previously. You state that the company's forecasts are regularly borne out with a relatively short period of the anticipated timing. Is that correct?
That is correct.
If you could put aside your rebuttal and please turn to the company's response to PSC-R-1.8G, which I should have provided. Just let me know when you're there.
8. Yep. Hang on a second.
G.
Yes, on the last page of the document that you gave me. I'm looking at it.
So in that response, you clarified that a relatively short period means that the actual change out occurred within 1 quarter before or after the quarter in which the change out was predicted to occur. Is that correct?
Yes, that is how we defined it.
Quarter is 3 months, correct?
Correct.
So when you said that the company's forecasts are regularly borne out within a relatively short period of the anticipated timing, another way to say that would be the company's forecasts are regularly borne out within 3 months before or 3 months after the forecasted date. Is that correct?
Yes.
So if you could now, I said to put it aside, could we go back to the work paper BBSWP-3B-4
Yes.
and the first page of that document?
Yes.
So you would agree that the change out timing forecasted by the company changed from its initial file, correct?
Correct. As I said, they're constantly updated as we get new information so that the initial estimate then is refined and ultimately finalized as we get operational data. So it's that final estimate based on once we have some test data to back it up that we make those final predictions where we say it's going to be either plus or minus a quarter around this date.
Of the 17 facilities that are listed on that work paper that we discussed, 10 reflect forecast revisions of more than 1 quarter, 3 months from the timing originally forecast by the company, correct?
Correct, because at the time that we make the original estimates, we often do not have, test data from after the previous change out. We begin that estimating period immediately after the most recent change out. And as we go along, as we proceed to then get the water quality data that comes as that new filter media is in service, then we continually update those forecasts. So yes, some of these changed by, 10, 16, 22 months. Those are from the original date where we are going off of our best estimate based on, whatever factors, whatever information we have available for a specific site at the time that the filter media is changed out. And then it's refined as we gather more data in subsequent months from there.
Your Honor, I'd like to move, will be Exhibit 38, the company's response to PSC-R-1.8G into evidence.
Any objection, Mr. Crumpler?
No objections, Your Honor.
Ms. Emerson?
No objections.
Thank you. It's moved in as Exhibit 38. Is that right, Mr.?
38, Your Honor, yes. You could put that document aside.
Very good. Thank you.
Can you please turn to the company's response to PSC-R-1.12A, along with the Excel attachment that the company provided with that response, and let me know when you have those documents.
So this is the 3 pages that you gave me. So you're looking at A on the first page and then the Excel document being the 3rd page.
Correct.
I'm looking at it.
Thank you. The company's response to PSC-R-1.12A, specifically the attachment that was provided with that, reports total 2025 filter media operating expense of $228,334.58. Is that correct?
Yes. That is what is recorded in the spreadsheet.
Can you turn to your rebuttal testimony, please? Specifically page 22.
So that would be the page that has the first question on it, or the topmost question being what occurred after the end of the test period?
Yes, and I'm going to ask you about that answer that you provided. So in that answer, you cite 4 changeouts between September 30th and December 31, 2025. Collins Park, Jefferson Farms, Midvale, and Wilmington Manor, costing a combined $509,841.64. All 4 of those occurred after the test period. Is that correct?
Yes, that is correct.
So comparing that figure with the figure we just looked at on exhibit, the Excel spreadsheet attachment A, the 228,334.58, they both cannot represent the company's total 2025 filter media operating expense, correct?
So the first one would be the costs that were incurred prior to the end of the test period, and then the additional cost would be the costs that were incurred after the test period.
Can you confirm that other years noted on the schedule that was provided in the company's response to PSC R-1.12 are also through September of that year rather than the full calendar year?
In those, I would need to review the exact numbers, but I would presume that they were the total cost for the entire year for those not up through September, since those years were completed.
So for that document, 2025 was the only year that showed January through September rather than the full calendar year. Is that correct?
I would believe so, yes, that would be the case.
Are you certain about that or are you speculating?
There is some speculation there, as it's been a while since I reviewed the exact details of what went into this, and this only has the 2 lines, so it's difficult for me to see.
Let me ask it a different way. Is there anything on the face of the document provided by the company that would delineate that for 2025 it was January through September, but not for other years?
No, I don't think there would be anything on the document that would delineate that.
Your Honor, I'd like to move into evidence as Exhibit 39, the company's response to PSC-R-1.12A, as well as the Excel spreadsheet attachment provided with that response that we've been discussing.
I see. Yes, Mr. Crumper, do you have objection?
No objections, Your Honor.
No objection.
Without objection, it'll be moved into the evidence, into the record as exhibit number 39.
Mr. Kostansky, can you turn to the company's response to PSC-R-3.16?
Yes, I have it in front of me.
You sponsored this discovery response, correct?
Yes, I did.
Your Honor, I don't have any further questions for the witness about the document, but staff will request that it be admitted into evidence as Exhibit 40. Again, is the company's response to PSC-R-3.16.
Mr. Crumple, you have any objection?
No objections, Your Honor.
No objection.
Then it'll be moved into the exhibit as, the record as Exhibit 40.
Thank you, Your Honor. No further questions for staff.
Mr. Crumple.
Yes, good afternoon. Oh. Sorry. Good afternoon, sir. Looking at your rebuttal testimony, you focus a lot on the acquisition adjustments by Artesian for Delaware City, Fort DuPont, Clayton, and Frankfurt, correct?
Yes, that is correct.
Okay. And at the beginning of your rebuttal testimony, you talk about how Artesian has acquired these systems, correct?
Yes, that is correct.
And looking at page 4 of your rebuttal testimony, as it's labeled here,
Mhm.
says Artesian recognized that ownership of Fort Delaware created the opportunity to resolve the system's lack of resiliency through the interconnection with Delaware City, while simultaneously providing a benefit to the citizens of Delaware City. Can you explain to me how existing Artesian customers will receive benefits even though the company's proposed acquisition adjustments will be paid by all of Artesian's customers?
So in this instance, it was that each of these systems, Fort DuPont and Delaware City, so in this case, both of them were going to be operating as independent systems with no redundancy and no ability to continue to provide water in the event that there was a failure at either of their treatment systems. And so we were looking to provide benefits to those customers by introducing additional resiliency by interconnecting them.
Okay. And if I understand correctly, acquiring these systems at a premium, am I accurate to say that Artesian won't incur additional costs due to expected future growth for these acquired systems?
I'm sorry, could you repeat the question or
Sure.
clarify just a little bit? I'm not entirely following.
Basically, with the Artesian acquired these systems at a premium, right?
In the sense that, yes, there was over the book value, yes.
And will the company not incur additional costs due to expected future growth from these systems?
So yeah, so the thinking behind this was that we would be able to offset future costs for both of the systems by being able to then rely on the existing infrastructure that was present in each of them.
Gotcha. And then on page 11 and the subsequent pages, you talk about Artesian's relationship with the town of Clayton, correct?
Give me just a second. I'm flipping to those pages, but yes, I see that this is the section of the testimony where I'm discussing the Clayton water system. So yes.
Okay. And specifically on page 13, you mentioned that Artesian's bid was approximately $2 million higher than the next highest bidder.
Yes, that is correct.
Okay. Do you know who the next highest bidder was?
I do not recall at this time. So, my head.
And briefly on the issue of filter media, these proposed costs go how far out again?
In terms of the filter media?
Yeah. Sorry.
The projection of 3 years.
And is that that's a projection, that's not, that for a fact it's 3 years?
In terms of how long we look out, or?
Yes.
So yes, we try to look out 3 years from change out date. So that's when we begin projecting out.
Give me 1 second here. I think those are all my questions at this time.
Any redirect?
The company has no further questions for Mr. Konstansky.
Sorry, I missed that, please.
No, the company does not have any further questions.
Okay, then can the witness be excused?
Yes.
Witness is excused.
Thank you, Your Honor.
We go off the record for a moment. Is this the time set aside for lunch? Emerson is up. Ms. Emerson's up, and we'll let her call her next witness.
The company calls Mr. David Spakes. Would the court reporter please swear him in?
David Spaked? I do.
Mr. Spakes' testimony is filed at Exhibits 13, 14, 15, 16, and 17. Can you please state your name and business address for the record?
And my name is David Spaked. I am located 664 Churchman's Road, Newark, Delaware, 19702.
By whom are you employed and in what capacity?
I'm employed by Artesian Water Company and Artesian Resources Corporation as the CFO of the corporation. I'm also president of the wastewater company.
Can you briefly describe your responsibilities in that role?
I am responsible for financial, regulatory, financing of the company. I'm also responsible for the wastewater company as well, all aspects.
Did you prepare and cause to be filed testimony in this proceeding?
I did.
Please identify the type and date of each testimony that you filed.
I filed direct testimony on April 4th of 2025, supplemental testimony on May 23rd of 25, a second supplemental for the second quarter of 8, filed on August 29th, 25, a final supplemental on December 1st, 25, and then rebuttal on April 17th, 2026.
And were your testimony and any associated schedules or exhibits prepared by you or under your direction and supervision?
They were.
Do you have any corrections, updates, or clarifications to your testimony as filed?
Not other than I've done through data requests, et cetera.
If I asked you the same questions today, would your answers be the same?
Yes,
Do you adopt your previously filed testimony, including all schedules and exhibits, as your testimony in this hearing?
I do.
And are the schedules and exhibits attached to your testimony the same as those filed in this proceeding?
Yes,
And to your knowledge, are those schedules and exhibits true and accurate to the best of your knowledge and belief?
yes.
Mr. Spakes available for cross-examination.
Your Honor, I would request that we go into a confidential session.
Yes, ma'am. How is that done procedurally? I don't see any members of the public here. Are there?
Well, we'll probably close the door
Uh,
and then stop recording, and Timon will usually put up a thing on the Zoom, a sign basically on the Zoom that says we're in a confidential session, so that if anyone joins the Zoom, they know what's going on.
Who handles that?
Whoever is running the Zoom, I believe Timon, she knows what's up.
So at the request of staff, we're going to go into confidential session for the discussion of certain confidential exhibits and documents.
Ms. Workman's still up.
Yes, I still have many questions that are for the whole public. So turning to your direct testimony. I'm looking at page 40.
You're on direct, right?
Yes.
Page 40.
Yes, starting at line 21.
Okay. I have it.
You state that Artesian anticipates a full operational workforce in place before the end of June 2025. Is that correct?
Correct.
Do you have PSC 1.5 in front of you? That
I
should
do.
be in the packet that I gave you.
I do.
And in response to PSC 1.5, the company stated, I'm looking at B, it did not include a vacancy rate nor apply any other methodology that reflects vacancies. Is that correct?
That's correct.
Your Honor, I'd like to move PSC 1.5 into evidence as Exhibit 45.
No objection.
No objection.
Record is Exhibit 45, is that correct?
Yes.
You?
Next, you should have a copy of PSC 1.4 with attachments.
I do.
I just want to note that the last page of that is what we're going to look at next. It's not part of the attachments. It's our next exhibit. It's just, they're all paper clipped together. Should have pictures on it.
Oh.
Yeah. And the documents produced are from Artesian's records. Is that correct?
They are in response to direct requests from PSC staff. So yes, those are from our records.
In those records, so I'm looking at the first page of the attachments. They report vacancies at 6 dates, beginning January 1st, 2022, and ending September 30th, 2025, which was the close of our test period. Is that correct?
Well, to be specific, on those exact dates, those are ones that were either filled or vacant. That's what the request was, on that date. Not up to or including, it was just on that date.
Okay, I understand. Then on the last page of that attachment, just to save time, staff calculated a vacancy rate at the bottom in italics. Do you see that?
Are we back to the graph page?
That's next. We're back. We're on
Oh.
the last page of the attachments to 1.4 in italics at the very bottom.
I see those.
Subject to check. Do those look correct? Do those figures look correct?
The calculation takes the end of year total employee base divided by the vacancies on that date. I would not characterize it as a rate of vacancy.
So just for purposes of this discussion, can we use the vacancy rate, which is unfilled versus overfilled? What was it? Unfilled over the total.
Again, I would not style it as a rate of vacancy. That's a particular percent of total employees vacant at that day. You want to do a rate of vacancy, that takes a lot of more calculations to even try and figure out. We don't have a rate of vacancy here. We have a percent on a day.
But for purposes of this discussion, can we move forward using those?
If you called a percent of total employees on that day, I'm happy to move forward. It is not a rate of vacancy. There's a difference in terminology. I'm not going to sign up to a rate of vacancy. It doesn't exist here.
Now I'm turning to the the graphs that were included.
I have that.
Can you take a moment to confirm that the exhibit accurately reproduces the company's numbers from PSC 1.4 attachment?
It does not.
How?
Again, it says rate of vacancy. The company never said it had a rate of vacancy noted in the table.
The
Noted
question is
therein.
not whether the title is to your satisfaction. The question is, do the numbers match the numbers on the table the company provided?
The numbers in the graph or in the table appear to match those that were listed at the bottom on the last page of the exhibit that the company provided up until that point. We did not calculate those percentages.
Okay, thank you. So I want to walk through what the company's records, which is that attachment to 1.4, PSC 1.4, show date by date. So on January 1st, 2022, 16 vacancies out of 241 positions. Does that look right?
On that date, yes, on that one date.
And then January 1st, 2023, 11 vacancies out of 236 positions. Is that
Again, on that one date.
January 1st, 2024, 17 of 243.
On that one day.
January 1st, 2025, 25 out of 251.
On that one day.
July 31st, 2025, 11 out of 252.
On that one day, yes.
And then on September 30th, 2025, 4 out of 252.
On that one day.
Did the company make any allowance for positions being unfilled at any time in their revenue requirement?
The company believed that at the end of the test period, it would have its full requirement. I believe testimony proved that we were short by 3, but that all the positions were filled and salaries known and measurable at that time. There was no need to account for a vacancy in that at that time we had no known vacancies, so there was none known and measurable. So the full, not quite the full complement was working at Artesian at that time, and the company was paying for their salaries, except for the 3 that I noted. And they were shortly thereafter hired, but so there was no need for a vacancy. They were all filled. We had filled positions.
So does the company's filing contain any study, forecast, or analysis which concludes that Artesian is going to operate at its 0 vacancy rate during the rate effective period?
Artesian believes that it will probably more than likely increase its number of employees based upon growth in its company to cover its customer base. Therefore, there may be vacancies that may arise, but the increase in the number of total employees will also increase. So we believe that the appropriate amount of employees calculated for the end of the test period was appropriate for the rate effective period.
I'm not asking about the company's belief. I'm asking if there's any study, forecast, or analysis that can conclude that Artesian's going to operate at zero vacancy during the rate effective period.
That is the company's analysis.
Is it
I
an
just told it.
What is that based on?
Based upon our history. If you look at the growth in the number of employees we have, they do grow as our customer base grows. There are vacancies, but you can also see that our vacancy rate or the number of vacancies on a given day may vary. The problem is that our number of employees continues to grow, and the net amount of employees needed to service our customer base continues to grow. So we've looked at that and indicated that during the rate effective period, the number of employees will grow, and there may be some that will change positions. There may be some positions that are vacant momentarily or shortly, but certainly not in this rate that's being calculated here for an entire year. You're suggesting that these positions are vacant for the entire year. That's what the adjustment that Mr. Pfaff proposes indicates. That's incorrect. It's not even close.
We're not talking about Mr. Pfaff's analysis right now. Is there any written analysis that the company has provided to staff or the DPA or that's in the record that shows that that the zero vacancy rate would be during the rate effective period?
All our analysis is in the case. It shows our progression in number of employees. It shows momentary vacancies, but that the employee base is growing so that they wipe out whatever momentary vacancies we may have. At the end of the day, we've proven that in our case. We've shown you every work paper that we have.
Can you indicate a specific one for us?
If you look at the year over year, 23 from 236 to 243, from 243 to 251 in 2023, from 251 to 252, from 252 and up to it's now at 252 at the end of the test period. So as our customer base grows, we tend to add a number of employees to cover those base. We should have another 3 on there, but we were unable to employ them by the end of the test period. They will continue to grow. It's just as a growing company, we'll see that. So we look at that and we look at the possibility of a vacancy and say the one will outstrip the other in the coming years.
How do you define a vacancy rate?
I don't define a vacancy rate. There are a number of issues involved with trying to calculate one. You'd have to know the position, whether or not that position was capitalized in terms of overhead or a straight expense, whether it was allocated to other of our subsidiaries, which some of these positions are. You'd have to know the amount of time that the position was vacant, whether the position that was open was filled by another employee whose position is then open, and you'd have to look at the time periods of each. That kind of study would take an inordinate amount of time, and when I look at the year-over-year growth of our employee base, I suggest that the number of employees growing more than compensates for any short-term vacancy that may or may not exist. You cannot look at a specific day, claim there's vacancies, and claim that day exists for the entire year. Simply inaccurate.
At this time, I'd like to move PSC 1.4 and attachments into evidence as Exhibit 46.
No objection, Your Honor.
Your Honor, I do not object to it being admitted into evidence, but I do want to note for the record that this is not the company's response. This is the company's response as annotated by the staff.
Good. That comment.
Next, you should have a copy of PSC 8.6 in front of you.
I have it.
As noted in that response, Artesian's employees contribute 2% of their medical premium cost. Is that correct?
Yes, that's what the response is.
And the remaining 98% of the premium is the portion the company pays, the employer share, correct?
Not exactly. Portion of it can be paid by allocated to other companies. So there are some employees that are allocated. There are some that are capitalized in overhead, and ours and the other subsidiaries. So, but in the true sense, the company, the corporation pays that.
So the split is 98-2.
At this time, yes.
Okay.
Although I would indicate that there is a different split on the dental, and there are other benefits that are differently accounted for. The dental benefits, I believe, are a higher percentage based upon different coverages. The employees also pay for AD&D, long-term disability. There are other factors there. So the medical is 2%, but there are other benefits that are differently covered.
Did staff make an adjustment with those other coverages that you just listed?
In one of the adjustments, it was swept into the adjustment, yes.
Which one?
It had to do with the inner whatever allowance that was there. There was a percent that was used and applied to the all benefits that was a little bit incorrect. I don't know exactly. I didn't go back and check all of them, but that was the gist of it. And when you do the percentage and you multiply it times the total payroll base, it gets muddled in there. So I can't say specifically, but I can say that there's muddling when you apply it to the entire payroll, the percentage to the entire payroll, which is how it was done.
The health insurance contribution percentage adjustment done by staff is just related to the health insurance. Is that correct?
If you could parse that out, and if you adjust for, because we did go back and adjust for the what is it, the credit that was given to us by the health company, yeah, it comes up to roughly that.
So next you should have a copy of PSC R 4.5. Do you have that?
Yep, I do.
In that response, the company states that its healthcare provider,
Excuse me, you want to move this last one into? How are we going to do this?
yes, I think
I'm trying to keep track.
it's possible I may be referring to it again later, but I have in my notes that I'm going to move them in at the end of this section just in case I have to refer back to them.
Good, you handle it the way you wish.
In that response, Artesian states that its healthcare provider uses the classifications individual, parent and child, parent and children, two-person, and family. Is that correct?
Correct.
And the 2% employee share is the same for every Artesian employee who takes the insurance. It doesn't change with the coverage classification. Is that correct?
But the rate of the amount of the payment's different because the rates are different per each of those classifications. In other words, the amount of the healthcare coverage is different for each one of those groups.
But just
the 2% is what they pay for their piece of the expense.
Yeah, so the percentage remains the same even though the numbers change.
With the healthcare, yes.
For healthcare.
But there's different classifications there. And at different rates. Each one has a different cost.
How long has the 2% employee contribution rate been in place at the company?
Over 20 years, at least. been in all of our filings for at least 20. I know it was increased at one point in time, but I think what was changed was the dental benefits. And again, I think of benefits in a package. So there's pieces of our benefits package that get treated differently. So as dental increases went up more steadily, we charge more to the employee to cover those. But I know in over 20 years that it's been on the medical side about the same. The others have changed substantially over the years to keep up with those costs. I don't know the exact date though, but it's been a long time.
In your direct testimony at page 12,
Oh, man. 13. Oh, page 12.
yes, I'm looking at starting at line 19.
I have that.
It states that Artesian manages its benefit costs for healthcare by increased employee premium contributions to reduce the effect of increases in employer paid premiums. Does that look right?
Yes, that's correct. We do.
So with the employee share sitting at 2% for many years, in what sense is the company managing costs through increased employee contributions?
Perhaps my previous discussion could have enlightened you. The dental, AD&D, long-term disability, all those were changed. All the underlying benefit costs were changed in terms of deductibles, in terms of what we cover and where we cover, and in classifications. There are a number of underlying parts of the healthcare package that we've adjusted to keep those rates down. On the dental side, we couldn't do as much, so we increased the cost to the employee by increasing the percentage covered. And then if they had other employees that, if an employee had a spouse, their primary had to be their employment to take their benefit or otherwise. So there were a number of factors other than that 2% in order to keep premiums down both to the company and then to the employee. So it's a whole range of changes to our benefit package that we implemented to keep those costs down. Not the least of which was going back, and I said 20 years, it's probably longer than that, when we got rid of our entire post-retirement benefit package to keep costs down to the customer and also to the company as well.
But just as a share of the premium, the employee contributions have stayed at 2%, correct?
As this states, though, the company had done its level best to keep its premiums down so that it could keep its costs down to its employees through that 2% mechanism. We did that by increasing deductibles and decreasing the amount of medical coverage that the employee actually received. On the
Again.
dental side, we had to do more.
Again,
So
just the employee contribution has stayed at 2%.
the employee
or no?
contribution stayed at 2%, but their benefits derived from the medical coverage decreased. Their deductibles went up, and what was covered went down. So there is an offset there. You can keep saying the 2%, that's incorrect. That's an incorrect characterization of what happened.
So we're moving on to your rebuttal testimony.
Okay.
I'm starting at page 18.
Give me just a moment. What exhibit number was that? Book 3. Okay. What was the page number?
18. Starting at the bottom.
18. Okay. I have that.
You state that Artesian competes for employees in a state where the largest employer is the state of Delaware, whose benefit package, pre and post retirement, is superior to that offered by Artesian. Is that correct?
Correct.
And when you refer to a benefit package, what are you including?
Well, both what the employee pays plus their post-retirement benefits that accrues to the benefit of the employees in the state. Because they get, there's coverage for medical after employment if you reach certain criteria. We have none of that at Artesian. Plus, there's a defined benefit plan. We don't have a defined benefit plan. We have a 401k plan, and that's it.
So what do you mean by what the employee pays? Is that their health insurance premium?
The percentage, as it were, yes.
Okay. And where did you obtain your information about the benefit package available to state employees?
Online.
Was that cited in your testimony or provided as a work paper?
I believe we provided it at a data request, but I'm not going to swear to that sitting here today.
Can you, and we can do this as a follow-up, give us that information where you pulled that from?
Sure.
So I guess formally, I'd like to make an on-the-record data request for the information that the company relied on with regard to the state benefit package.
And I would only note, one of the other sources were some of our prospective employees that were formerly state and/or county employees that both waited till retirement to obtain their full benefit package before joining us. And that was one of their requirements, that they got the full medical at certain, and I don't remember the criteria, whether it was 20 or 25 years with the state or county. So I know that it existed, and I know it still exists today, but that was one of the other sources. It's word of mouth from the actual state employees that joined us. And county, too.
So from that quote we just read from your rebuttal testimony, you use the word superior to describe the comparison of the state of Delaware's benefit package compared to Artesian's. Is that right?
Absolutely.
And like you just said, the state of Delaware provides its employees a defined benefit pension and retiree health coverage, while Artesian provides a defined contribution 401k plan, right?
That's correct.
And those are structurally different retirement plans, correct?
That's correct.
I can clarify regarding Kate's on the record, Ms. Workman's on the record data request that Exhibit 2 to
Please speak up.
Exhibit 2 to Exhibit 17 is the Exhibit 2 to Mr. Spake's rebuttal testimony.
Oh, yeah, there it is. Should be in your binder there. If you look at the RT-DBS EX2, it's right behind there. Go to my rebuttal testimony, and it's RT.
Ms. Workman, may I clarify? Did you just ask him for, you just asked him for some supplemental information that he's agreed to provide?
Yes, but then Ms. Emerson showed us where in the exhibits that supplemental information was. And so we no longer need that supplemental information.
I'm very concerned anytime there are additional information coming in and the record stays open. So I was going to ask him if he could do it within 48 hours, but maybe not necessary now. So just a note, I'm worried about keeping the record open.
Yes, that was my error.
No, that's fine.
They provided it. So you state in your rebuttal testimony that Artesian competes for employees with the state, right?
Yes,
So compensation and benefits are among the principal ways an employer competes for employees. That sound right?
that's one of the ways, yes. Especially for the older employees with more experience, if they're close enough to retirement or a place where they can leave the state and still enjoy those post-retirement benefits, they choose to wait.
And so an employee choosing between two employers would weigh the entire compensation package, which includes salary, health insurance, retirement, paid time off, rather than just a single benefit in isolation. Is that correct?
That's what I've argued about compensation my entire career, including this case.
You've argued that what
Mhm.
compensation includes all of those things.
Sure, that's what we've been talking about all along with the adjustments that have been made to benefit packages, compensation studies, wages, all that. You have to look at the package and how we compete against others.
And so did the company in its testimony compare all elements of compensation between the state and Artesian?
Not at the time, no. We compared the benefits because that was what was appropriate in this instance because they were broken apart. But as employers, our HR department looks at all those elements and how it attracts employees. Again, we've had instances where we've tried to hire either state or county employees and couldn't because at the time, the benefit package we provided couldn't match that of what they were getting from the state, regardless of the salary. So, yeah, we're looking at it all and we compare it all. So, if we can't compete on one, we try to go with salary, but we have to stay within our ranges. So you're looking at the whole package of benefit to the employee that we're trying to attract. Our HR department does that. We can't do it in the context of this application.
Did the company perform a benchmarking of total compensation to other companies?
I think there was an attempt to do that in the compensation study provided. I don't know that they could break out the different elements as we've tried to do. That study is much more encompassing. But that was the attempt in the compensation study. But there are obviously other elements, especially in a state where the largest employer is the state.
Wasn't the compensation study just wages?
It talks about compensation and they look at other elements. I don't know exactly all the elements went into the package. That's why they develop a range of highs and lows. They look at all elements in there, and whether or not individual pieces of a benefit package are included, I can't tell. I did not participate in that study. I can tell you though that we look at that study, what they pay in terms of benefits, that 2% or the 30, whatever they pay for the dental, the whole package, and then look at that in terms of other employees coming to us and saying, is it a reasonable all-in package, the expense? So you have to look at the entire expense for that payroll benefit package together for each employee group and make sure that we're able to attract. In some cases we do, in some cases we don't.
Going back to page 18 of your rebuttal, I'm looking at the second sentence. You state, the state of Delaware has a benefit program where the employee contribution for benefits is comparable. Do you see that?
I do.
And in front of you, you should have a copy of the 2026 State of Delaware Group Health Insurance Plan.
Where might that be?
So I think you have an extra exhibit. I took some questions out.
The one that we provided.
Yeah, well, it's also in the packet that I provided.
Oh, is it?
Yeah, it should be, there's a, what is it, Form 10K, and then the next document
Gotcha.
should be,
I have it. Yeah.
all right. On that exhibit, the state's lowest cost medical plan, which is the Highmark Delaware First State Basic Plan, requires the employee to pay $44.70 out of a $1,117.72 premium. Do you know what the employee contribution percentage of that is?
Not off the top of my head, but it looks something between 3 and 4%. I might add, though, that when we talk about comparable benefits, we don't have post-retirement benefits. State does. So they get to pay that in perpetuity after they retire. Artesian, they do not. So when I talk about comparable, the benefits package is superior on the state side.
Well, right now I'm just asking about the medical. And going back to what we had just read from your rebuttal, this is specifically about employee contribution for benefits, not compensation, just benefits.
I'm not sure that's what it says. Please point me back to the sentence again.
Second sentence, page 18.
The state of Delaware has a benefit program. That doesn't sound like I'm talking about just the rate of payment by the employee. The program suggests that not only do they get the discount here, but they get also post-retirement benefit at that same rate. That does not accrue to the
But
benefit
if
of
we were to
Artesian customers.
continue to read the whole
employees.
sentence, a benefit program where the employee contribution for benefits is comparable.
Right,
That's the rest of that sentence.
correct.
But going back to the $44.70 out of 1,117, subject to check, you would agree that 3.99% is a reasonable number.
Is that the percentage that you paid? Yeah, I don't know how the dollar amount stacks up. You know, that 44.70, I don't know how that stacks up against what the employee pays for Artesian sitting here today. I'd have to go back and look that up.
I was just converting that 44.70 over 1,117 into a percentage.
Yeah, but percentage is not a direct comparison if the base is not the same. It's how much the employee actually pays. That's the compensation number. Percentages you can make do anything. You got to have a base and you got to have what they pay. So what did the company pay? What did the employee pay? On the Artesian side, what did the company pay? What did the employee pay? And is it comparable?
All right.
Percentages could be anything.
Employee contribution percentage. So that's where I'm focused right now is, a 3.99, almost 4%.
But if you're talking about a benefit program, percentages are relevant.
Employee contribution percentages. And 4%, which is about what a state employee would pay under the lowest cost medical plan, the Highmark Delaware First State Basic Plan, is double Artesian's 2%, correct?
The percentage is, but the necessary underlying dollars may not be. And that's the point. It's the dollars, not the percent. Percents are irrelevant unless you know the base.
So if in your rebuttal testimony, you were saying
You've lost the internet.
Oh.
It just went off. Oh, there we are. We're back.
So from that quote from page 18 of your rebuttal, which again, the state of Delaware has a benefit program where the employee contribution for benefits is comparable. Are you comparing the percentage contribution or are you comparing the dollar amount contribution?
I'm comparing the entire package here because I can't just focus on one person. You have different levels, so do we. So you have to look at the entire package and say it's comparable. Plus, you have the post-retirement benefits again.
So what in that sentence is the significance of the employee contribution if you're only talking about the entire benefits package?
I'm not quite sure what the question is. We looked at what the employee pays, and we looked at what the company pays and said they're comparable. There are a number of different levels of premiums paid and how much the employee pays towards those premiums. And we looked at the companies and indicated they're comparable. But there's a number of different levels of payments depending on the plan you choose. I didn't look at the percentage per se.
So did you compare the dollar amounts? Is that what you compared?
Yeah, I looked at the dollar amounts that the employees are paying, and I looked at the dollar amounts of the premiums that are being paid by the state. Obviously, you have different packages. We have different packages. Like I said, we have higher deductibles so that we have lower premiums. Maybe there's on different levels. There's different amounts of premiums that the state pays and different levels we pay. So you got to look at the dollars. You can't just look at the percentages. Anybody can come up with a percent.
You just said a few minutes ago that you didn't know the dollars. You didn't compare the dollars.
We look at the entire package. Like if you look at our package, you can see that we do by employee how much they pay for each thing. We listed it out in the work papers. So we know how much each of our employees pay. So I looked at that and looked at the amount of premiums that are being paid by the state and what the company or the employee pays by the state and made a reasonable assumption just looking at those numbers. I didn't look at the percentage. Again, it's based upon the premium. It's not based upon the percentage that they pay. That's a mechanism to show, but I mean, it's the dollar amount that is included in compensation that then goes to the total package. So you just can't just say, oh, it's 4%, we're 2% and call it a day. That's an incorrect analysis.
At this time, I'd like to move PSC 8.6 into evidence as Exhibit 47.
Rumpler, you have objection?
No objections, Your Honor.
No objection.
Moved into the record. That's the next succeeding exhibit number, which is
47, Your Honor.
47. Don't you go away.
So just to confirm, you did a comparison between the employee contribution dollar amounts for the Artesian versus the state.
Yeah, I think it was more on the premium end up being paid by the company because I don't think we showed the employee amount. I think we showed the amount that was being paid for by the company, if I recall correctly. So I looked at those and said, I can't tell what benefits are being paid in the packages here. I know what ours are, and I could make a reasonable assumption. That's what I looked at.
And do you know where that could be located in the record?
It'd be in the work papers for our each employee we had listed out. That's where Mr. Pfaff did some of his calculations on. It was by employee. You could see which part was paid by the company. Or couldn't make it out from there.
But is there a comparison between employee contribution?
I did not take this sheet and try to superimpose it there. That's not my relative. I couldn't do that for every single employee. I don't know which employees the state, has. I can only make reasonable assumptions, and that's what I did.
So is that a no?
I made a comparison using this, not this sheet, because we had an older version of this sheet. This was put in because it was just updated, but I think they get one every year. So we looked at it and we said they're about comparable. It was just a top side view.
If it's just a top side view, we don't have that exact comparison in the record, right?
I have the rates that we had. I have our rates. I know that the state provides post-retirement benefits that include all this health care extending through the life of the employee post-retirement. And I made that analysis without going through every single state employee and trying to recalculate. Yes, that would be what I term topside.
At this point, I'd like to move PSC R 4.5 into evidence as exhibit number 48.
Bumper, any objection?
No objections, Your Honor.
Ms. Emerson.
No objection.
Without objection, it's moved into the record.
I would also like to move the 2026 State of Delaware Group Health Insurance Plan into evidence as exhibit number 49.
Objection, Mr. Crumpler.
No objections, Your Honor.
Ms. Emerson.
I have no objections, though it's already in evidence.
It is, but for
That's fine.
ease of reference, I'd like it here as well.
See the harm in that. Without objection, so ordered.
All right, the next few documents we're going to be referencing, you should have Schedule 3B 13 from 25-0346, Schedule 3B 14 from 25-0346, and then supplemental schedule DBS 3B-13 from docket number 23-0601. Do you have all three of those?
Need a paperweight over here. You're not using this then?
No, I nixed that.
Ditch that. Our financials. I have them.
All right. So the two schedules from this rate case, the Schedule 3B 13 and 14, those were provided by the company for an adjustment of $859,089. Is that correct?
There's two 3B13s here, right?
Yeah, so the one from 25-0346,
20.
this rate case.
Oh, okay, there it is. All right, sorry. Yes, it's I'm sorry, say that number again.
$859,089.
That's the depreciation reserve adjustment 5-year amortization. Yes.
Yes, so you agree with that number for the
Yes,
depreciation?
I do.
Okay. And in the 230601 case, which again is the supplemental schedule DBS 3B-13 from docket number 23-0601, there's an adjustment. That same adjustment from that case is $692,797.
Yes, and if I might explain, this schedule was provided prior to those settlement discussions, and was not updated for current information. This study included those elements up through 2022. So between then, which was the end date of that depreciation study, till the time of settlement and commission order, the company had other assets that it had purchased within these categories. So in order to have the depreciation cover what the idea was behind these, the depreciation change, which was to go from a mass class asset depreciation to individual depreciation, that number had to be adjusted or we wouldn't account for any of the assets that were acquired from the end of the study period to when the rates were actually, or when the order was actually adopted or approved. So that's the difference between the two numbers.
And it's the same type of adjustment in 230601 as it is in the current rate case?
23601, and I only have the one side of this, but yes, I mean, it would necessarily reduce the accumulated depreciation. It would increase the accumulated depreciation. Yes.
And do you have PSC 7.2 in front of you?
7.2, yes, I have it here. Yes.
So this response, in the request, you were asked about your understanding of the purpose of the depreciation reserve adjustment. And then the response objects to the question because it addresses another witness's testimony in a previous rate proceeding. And then it directs staff to that testimony from the previous rate case.
Yep, and in the end, it says, however, by way of further response, and it goes on to talk about just what I just explained here earlier, that there's a difference between the time that study was completed and the amount that had to be included in those specific accounts for depreciation purposes.
And the company witness from 230601, Mr. Spanos, is not a witness in this proceeding. Is that correct?
He's not a witness in this proceeding, no. He was presented for the depreciation study. He had recommended a change in the methodology for depreciation of specific assets, which included these specific general assets. And those general assets at the time of his study, through the end of 2022 again, were at a certain amount. Between the end of that time period and when the order was finally entered, we added more assets to it, so it had to be adjusted.
Yes or no? Is he a witness in this proceeding?
He is not a witness in this proceeding.
And the company has not offered him to support any adjustment in this case?
No, I have made those adjustments to the balances, not to his recommendations, but to the balances that are represented in those accounts. And again, his recommendations simply went to the accounts. Those were mathematical calculations made from his recommendations.
So you sponsor that $859,089 depreciation reserve adjustment in this proceeding, right?
That was because of the changes in the account dollars, yes. Between the time that the study was done and the time the order was entered by the Public Service Commission. We couldn't change our accounting at the time, nor change the study. It was not included, the 800 was not included in the rates that were charged to customers at that time. It was done after the fact. But that's what's in there, and that's the amortization that's been done since that order.
And you're familiar with Mr. Pfaff's testimony in this proceeding, including the portion that addresses the depreciation reserve adjustment?
I am.
So in front of you, you should also have staff's second set of rebuttal data requests with the responses.
I do. That's 2.1?
Yeah, starting at 2.1, it goes 2.1 through 2.4.
I see those.
So I'm looking at PSC rebuttal 2.4, so PSC R 2.4.
I'm sorry, is that another one?
No, it's in the second It's in the packet. You have the,
Okay, the first one doesn't deal with depreciation. That's where I was trying to.
yeah, so PSCR 2.1 is the first page. On page 5 out of 7 is where PSCR 2.4 is.
I have that. Okay.
And although the company contests Mr. Paff's proposed adjustment to this item in its response to PSC R 2.4, the company confirmed that it did not file any pre-filed rebuttal testimony addressing the depreciation reserve adjustment. Is that correct?
Now, we had responded in data requests explaining the difference and assumed that settled the situation as an account change. So we did not get that in our rebuttal.
You have Mr. Paff's direct testimony?
Probably. I do here somewhere. Can you give me a cite to it?
Well, I'm looking at page 22. I'm not sure.
Hold on a second. Let me get to it. 19. Page 22.
Yes.
Okay, I have it.
Please go to line 14.
14. Does the company explain?
Mr. Paff asks whether the company adequately explains the basis for the $859,089 adjustment, and Mr. Paff says no. Do you see that?
I do see that.
And then Mr. Paff goes on in his testimony to provide the reasoning for that conclusion. The first basis is that the company's discovery responses on this adjustment are inconsistent, and he points to 2 specific responses, PSC 7.2.
I'm sorry, which PSC what?
I'm just looking at Mr. Paff's testimony right now. Well, we're going to get to.
I'd like to turn to that if you're referring to it. So which 7.2, is that the one you're talking about? Okay, that's the one we just talked about,
Yeah.
where I explained that the difference in the numbers had to do with the purchasing of additional assets. Yeah, I see that. So we did explain it. He just didn't understand it, apparently.
So the depreciation reserve adjustment is, when will that be fully amortized?
2028, I guess it was a 5-year depreciation. All right, 2023 it started, so I'm guessing 2028. Sounds right.
So in the PSC response, or the company's response to PSC 7.2, the company stated that the depreciation disadjustment was specifically agreed to. Is that correct?
The methodology was agreed to. methodology and rates of depreciation were agreed to. We had to adjust the account balance to account for the change in time.
So,
Spoke to here in the response.
so 7.2, this is a quote from the company's response. Since this adjustment was specifically agreed to in the settlement agreement in PSC docket 23-0601 approved by the PSC order. That correct? That I read that right?
You read from that response.
And then in that response, the company says all relevant testimony can be found in the testimony of witness Spanos, which was filed in 23-0601. That's correct?
Correct. He spoke to the recommendation of the methodology for dealing with the adjustments there. We had to deal with the account balances. That's how we changed.
And then in that response, the company said no further justification is required by the company, correct?
Went on to say, however, by way of further response, and talked about the mass asset accounting, the change recommendation, and why we had to use the current count balance to come up with the amortization. Otherwise, there would be an amount left in there that wouldn't be amortized or adjusted through the life of the asset. So the only way to get rid of that is to put it into the balance and adjust for it as he had recommended in his study.
But did I read that correctly, that 7.32, even without the context you,
7.32?
I'm sorry, 7.2, without the context you just added, said that
Again.
no further justification is required by the company?
Except that at the end, I did go
So
into
it's a
further
yes or no
comment.
question.
Then it's no.
Is there a quote in there that says no further justification is required by the company?
No further justification required by the company. However, by way of further response,
Was that a yes?
understanding of the adjustment is transitioning. Those words are there, but there's a justification that follows, immediately follows that answer.
Thank you. In front of you, you should have the company's response to DPA 2.31.
Say that again. DPA 231.
Yes,
Do I
2.31.
need this one again?
Which one?
7.2.
Maybe.
Maybe. All right, I'm getting some maybes here, so
I would say
file to file them again.
solid maybe.
231 has attachments or no?
No, it's just the one
Okay.
piece of paper.
Good.
And DPA 2.31 asks the company to provide a detailed explanation of what the depreciation reserve adjustment amounts reflect. Is that correct?
Yes. Yes.
And in answer to that request, the company referenced analysis, or stated that analysis was constructed following the conclusion of PSC docket 23-0601. That's a accurate quotation from the company's response, right?
It goes through a detailed analysis of what we did. Yes.
And it says that the analysis was constructed following the conclusion of PSC docket 23-0601, right?
Correct.
Mr. Paff in his testimony says that what we've read from 7.2 and what we've read from DPA 2.31 are two incompatible arguments. He compares the adjustment on one hand, the adjustment that was specifically agreed to in docket number 23-0601, and that all the relevant testimony can be found in that docket. But then on the other hand, there's the adjustment that is based on analysis developed following the conclusion of 23-0601. And that is what you disagree with, correct? Mr. Paff's statement that those two are responses are incompatible.
I'm going to say incorrect. I think Mr. Pfaff had a misunderstanding of what was agreed to and what the study said versus what had to be accomplished to not have an orphaned amount left in an account by not depreciating it. That's what I see here. That's the only thing I can understand. Is there's a misunderstanding. Never got it cleared, even though we tried to explain it on a number of occasions. He was not part of that case, I guess, or part of that settlement. I'm not sure, or maybe misunderstood the study. But the study dealt with a recommendation and a methodology for getting rid of a balance. We followed that by just had to update the account balances between the time that it was done and then when the case was finally completed. There's always a delay. You have to update the numbers or they get orphaned.
Was modifying the adjustment a provision of the settlement in 230601?
I didn't modify any adjustment. We didn't modify the amount that we put into rates. We didn't do any of that. We updated the amount that was in the balance of that account that the recommended methodology for getting rid of the balance entailed. That's all we did. We didn't update any of the numbers in the case at the settlement. The settlement was the settlement. We updated the balances to reflect what the recommendation was from the study and how it was accepted by the group.
But by updating the numbers, you modified the adjustment that was agreed to.
I didn't modify an adjustment that was agreed to. We agreed to the settlement and the depreciation study and the rates that were included in that depreciation study. That included a 5-year amortization of the depreciation reserve balance in order to make sure that we got the entirety of that balance adjusted throughout the 5-year period. It had to reflect the current account balance. Otherwise, there would be an orphaned amount of assets that were left in those accounts. That's what happened. There was a delay between the study, which was the end of 2022 balances, and when the case was completed, which was in 2024 eventually. So by the time that happened, there was some purchases had to be included in the balances. The balances had to be adjusted. That was the recommended adjustment that was made. There was nothing done to any of the amounts in the settlement. The settlement, it was what it was.
So the figure reflecting current balances, the $859,089 figure itself was not specifically agreed to in docket 230601, and then it's not found in the relevant testimony in that docket. So it's the output of later analysis with updated figures, correct?
That is the analysis using the recommendations of the rate of depreciation that was used in that study to come up with what the new rate expense would be. In that part of that case, we ended with the settlement being what it was. We took the amortization, though, using the new number because we had to for our books and records. So nothing changed in the settlement, but we had to reflect those additional assets or else they'd be orphaned. There's no other way to do it.
So when did the amortization start?
After that case.
Wait, when was that, though? Do you have a specific date?
It would have been after the date of that order. That's the only time we can change our rate of depreciation. So whatever that date was, I don't have it specifically in front of me. It would have been probably in 2024, I'm guessing.
So whatever date the rates went into effect, right?
Sure, yeah, because that's the only time we can change the rate of depreciation is when it's ordered.
And in 5 years, that'll be fully amortized, right?
Yes. Could I take just a moment to recharge?
I'm about to move a bunch of stuff into evidence, so
Oh, good.
go be free for a minute. Mr. Kenton, at this time, I'd like to move Schedule 3B13 from 25-0346 into evidence as Exhibit 50.
Mr. Crumpler.
No objection, Your Honor.
No objection.
Objection is moved into evidence as Exhibit 50.
I would also like to move into evidence Schedule 3B14 from 25-0346 into evidence as Exhibit 51.
Clerk,
No objection, Your Honor.
Emerson,
No objection.
moved in as Exhibit 51, approved.
I would also like to move into evidence Supplemental Schedule DBS 3B13 from 23-0601 into evidence as Exhibit number 52.
Rumper,
No objection, Your Honor.
Emerson,
No objection.
without objection, so ordered.
I would also like to move into evidence PSC 7.2.
Okay.
No objection, Your Honor.
No objection.
Without objection, the case entered into evidence.
I'd also like to move into evidence PSC R 2.4 as exhibit number 54.
Rumper,
No objection.
No objection.
without objection, so moved, entered into evidence.
And I would like to move DPA 2.31 into the record or into evidence as exhibit number 56.
Rumper,
No objection.
No objection.
moved.
DPA 2.31 exhibit 55.
Objection, Mr.
No objection.
That's the same exhibit. I'm just confirming that it's number 55. I think I accidentally said it was 56.
Any objection, Mr. Gumpler?
None.
No, Your Honor.
Without objection, so ordered, moved to evidence.
Mr. Spate, that packet of papers with PSCR 2.1 through 2.4, we're going to come back to that. So if you want to keep it handy for later.
Ms. Workman, is this a good time to take a break?
It's a great time to take a break.
Always. Take a break for 10 minutes, make it 2, 20 minutes to 4.
Okay.
Available to the PSC. Is that correct?
Yeah, we had provided it in our 3H. It showed both, what was there. I think it was 3H.
So what's the information that you relied on to support your statement that we just read from your rebuttal?
That was supplemented by the response to the data request?
Yeah.
It was just the level of expense that we saw from the staff and the PSC broken down by different categories.
So your answer to C 2. Or PSC R 2.2C said that the information is based on invoices from the PSC and that the company doesn't maintain invoices from 2014. Is that correct?
That's correct. Yeah, we could only use what we had in our summaries from that we had filed with the dockets. 23601 would have had the summary of the 2014 case. So we looked at that and tried to note the similarity or differences between the cases and came up with our estimate based upon that.
So did you review the invoices from 2014?
We didn't have the invoices. I had reviewed them at the time, but all I could go by is what was on the summary sheet for the 3H and docket 23601.
You can't identify any specific invoice that you reviewed to support your statement?
Again, there were none. I went back to the 23 case, in which case the 14 case is listed there next to that in 3H on DBS Exhibit 1.
Thank you. The next file in the packet that I gave you should be an email. You can just go right on past that. And then,
The interaction allowance clarification, is that what you're looking at?
yeah, just move on right past that. We're not going to talk about it. The next document should be Schedule 3H.
Got it.
Is the rate case expense from 250346.
I have it.
The largest component of the company's rate case expense is labeled PSC charges, and that's estimated at $695,664. Is that correct?
Correct.
Next, we have PSC 1.11.
Got it.
And in that request, staff asked for you to explain how the $695,664 figure was developed, correct?
That's correct. Yes, we didn't have information from staff to use a number, so we looked at the last case. It was a settled case. We didn't go to hearings or anything, so we knew that that would require much more time and effort on the part of staff, and about what happens in these cases, about double the cost. And that's what we did. About. I mean, it's not exactly, but it's about.
So you estimated that the application would be approximately double than the last proceeding, 230601, right?
By the time that we would get through hearings, briefings, and before the commission, yes, because we didn't have any of that in the last case. We settled shortly after we filed rebuttal, and there was no prep for hearings or briefings or anything else, and that requires a lot of expense.
And so that comes from comparing the 14132 case to the 11207 case, in which the 14132 was fully litigated, and that was approximately double the 11207 and the 23601 cases, right?
That's what we looked at. Yep. Yes. They were estimates only because staff couldn't give us a detailed analysis of what the cost would be. So we took our best shot at it.
Did you ask staff for that information?
At the time, I'm not sure that we did. No. I know we've asked for some information, but I don't know that you had it at the time we filed the case. You didn't even have consultants at that time. So that would have been nearly impossible to get that amount from staff. They didn't know about it when we first filed. We did reduce our legal expense substantially from the last case because we are not using outside counsel anymore. So that was a benefit.
So after staff hired consultants, did you ever ask for that information?
We did not. We could get that information and we can only guess. Again, we didn't know whether we were settling or not. Those information was only through the initial filing. So any of the work that had to be done, answering data requests, coming to trial, hearings, briefings, all that, there's no way we would have gotten that estimate. So we didn't pursue it any further. We figured this case, the cost of this case, we had reduced substantially because of our reduction in our legal expenses. We felt that the amount of the expense was reasonable given the amount of time and effort that would be required through litigation, full litigation. Because again, you said only the PSC lines, you didn't look at the other lines and note the reductions there. So
The company's schedule DBS 3H. The PSC charges for docket number 230601 were $347,832. Does that look right?
yep, through settlement. Yep.
And the PSC charges for docket number 14132 were $208,254. Does that seem right?
That's what we had from that case 10 or more years ago. Yes. $12 years. Sorry.
So the PSC charges that are estimated are in large part the costs of the commission staff and the DPA, which includes consultants and is billed through the company, right?
I believe they're all the charges associated with PSC, including whatever charges the hearing examiner or any other costs associated with the case that the PSC may pass through to us. I don't know if it's just those. But yeah, those are primarily everything that's charged for you, everything that's charged for the DPA, anything that the commission has to, the court reporter, all those charges are all included in that. I don't have a specific list of all the charges. There's a number, including the hearing examiner.
All right, at this point, I'd like to move into evidence PSCR 2.2 as exhibit number 56.
Mr. Crumpler, any objection?
No objections, Your Honor.
No objection.
So moved into evidence.
I'd like to move into evidence Schedule 3H, rate case expense from 25-0346 into evidence as exhibit number 57.
Rate case expenses, exhibit number 57. Mr. Crumpler, any objection?
No objections, Your Honor.
Ms. Honor?
No objections.
So moved into evidence.
I'd like to move into evidence PSC 1.11 as exhibit number.
Excuse me, folks. I must interrupt this for a second. I've got a crisis call here.
Take as much time as you need, Your Honor.
You had 2 3H's, you know that, right?
I would like to move PSC 1.11 into evidence as Exhibit 58. Yes, Exhibit 58, PSC 1.11 to move into evidence as Exhibit 58.
No objections.
No objections.
Without objections, moved into evidence.
And Your Honor, at this point, I'm going to request to move into evidence a bunch of documents that I do not have specific questions for Mr. Spade about, but I'd be happy to make them up if anyone has any objections, but I think everyone would rather do it quickly this way. Okay.
But I'd like you to, yes, go through each one and just identify it, and then we'll move it into the record and we'll go forward that way.
I would like to move supplemental schedule DBS 3H rate case expenses from 23-0601 into evidence as exhibit number 59.
Let's move them all at one time, so let's go through the whole group.
Okay. As exhibit number 60, PSC 4.5. As exhibit number 61, PSC R 1.3. As exhibit number 62, PSC R 1.14. As exhibit number 63, PSC 6.6.
Ms. Workman, did you mean 1.14 for
Yes, I
Exhibit
did.
62?
Yes. Number 62, PSC R 1.14. I typed it right. And then 63 was PSC 6.6. 64, PSC 7.1. 65, PSC 7.3. 66, PSC 8.7. 67, PSC 8.8. 68, PSC 8.9. And then 69, PSC 8.12. I would like to request that we move exhibits 59 through 69 into evidence.
Mr. Crumper, do you have any objections?
No objections, Your Honor.
No objections.
No objection. All those 10 exhibits are moved into the record as described by Ms. Workman.
I'm going to turn it over to my co-counsel, Mr. Ferguson, to ask Mr. Spate questions that were deferred from other witnesses earlier.
Sorry, I missed the end of that.
There were some questions that other witnesses earlier today deferred to Mr. Spate, so I'm going to turn it over to my co-counsel to ask those questions.
Please
May I
proceed.
Good afternoon, Mr. Spate. You were here for Mr. Kostanski's testimony, correct?
I was.
You heard him testify regarding the 2025 filter media operating expenses that were provided by the company in response to PSCR 1.12A and the attachment that the company provided with that response.
Correct.
And the company stated in that response that the 2025 filter media operating expenses were $228,334.58, correct?
Yes.
And Mr. Kostanski then testified that he was not certain, but speculated that the $228,000 figure given was not for the calendar year, but was for January through September 30th, 2025. Do you recall that?
Yes.
And Mr. Kostansky identified that you might have more knowledge on this topic. So is it correct that the $228,000 figure in that document for 2025 filter media operating expenses is for 9 months versus the entire calendar year?
The 228, yes, was for a quarter, the beginning quarter 2025. We listed in our testimony on 3B4 the 391,823, which would have been the 12 months ended September of 25. There was an additional 270 in the final quarter of 2025 of expense. Maybe he could have been referring to that, but in the fourth quarter of 2025, there was an additional 270, over 270 some $1,000. I'm just guessing that that could have been the amount that they were confused with. I don't know, but the total amount in the test period was 391,823.
So you're saying the 228 figure that's listed on that document, $228,000, it's just for the first quarter of 2025? Is that your testimony?
I believe it was, yes.
The face of the document provided by the company did not indicate that the 2025 expense was just for the first quarter of that year, correct?
I don't have it here with me. I went back and looked at the quarters, and that 228 was the first quarter of 2025, but the 391,823 was for the 12 months ended 9/30/25. So that would have been included in that. Then if you go forward in the fourth quarter, there's another 271,000 roughly in the fourth quarter of 2025. Just updating.
Your Honor, may I approach and give Mr. Spate a copy of the same document I gave Mr. Kostansky? For the record, I provided the witness a copy of PSR 1.12A and attachment. And so my question, Mr. Spade, is whether from the face of that document, staff could understand that the $228,000 figure was only for the first quarter of 2025 versus the entire calendar year.
I'm sorry. I'm trying to find out where the 228 is. Oh, is that on this last sheet? Is that what you're looking at?
Attachment. 2025.
Yeah, the only thing it says was, yeah, but that was the first quarter of 2025. I mean, I know because I just asked during the break after while he was testifying, but it doesn't say that there. I'm sorry?
You wouldn't know that from the face of the document, correct?
It does not say first quarter. Let me read through what he gave you here. This is not. Was this an attachment to our response?
Was, yes.
Was it referred to in the response?
It is. So if you look at PSR, PSCR 1.12A, says Artesian objects to this request as it unduly burdensome. However, by way of further response, the company is providing a breakdown of expenses for filter media by year for the years requested. And then the attachment that you have is what that refers to.
Yeah, I'm not sure why this was only for the first quarter, but that's what it was after checking.
Are the rest of the years on the spreadsheet for the full calendar year, 21 to 24?
I know that 2024 was because I went back and checked that as it related to the test year. I did not go back and check 23, 22, and 21. I know for 24 it is, and I know for 25 that's the first quarter. I was looking at test period information. So I know those two are right. I did not go back and check 23 and 22 and 21. I could do that. I wouldn't take us long to check that, but I can't do it sitting here today.
You may have already said it in several numbers, but so what would the total be for filter media operating expenses for the calendar year 2025?
For the calendar year, it would be 600 and over 661,000 for the calendar year. I think, again, I'd like to double check, but that's my understanding. Actually, they are GL accounts, so they're easily obtainable. I mean, I just don't have it sitting here. I only checked a couple of them. Sorry.
Could you turn to Mr. Kostansky's rebuttal testimony?
Give me the.
12, Exhibit 12 for you
12?
in your binder.
I got it. Yes. Any page?
So there's no page numbers. We went through this before, but I believe if you don't count the cover page, it's page 22.
Okay, which is the last page. Okay. Second,
It's the last page.
second to last page.
What is the first line on the page?
First line on the page is reality that filter media replacement is a continuing precise timing.
That's not,
I think it's 2 pages back, Mr. Spate.
got it. Okay, I'm on the right
Did you
page.
see the question, what occurred after the end of the test period?
Yep. Yeah.
And Mr. Kostansky testifies between September 30th, 2025 and December 31st, 2025, and he identifies 4 facilities with filter media changeouts. Do you see that?
I do.
The combined cost, he testifies, was $509,841.64. Do you see that?
I do.
Going back to your prior answer that the total operating expense for 2025 was over 661,000. Can you explain that using the 509,841 number plus the 228,000 figure we have from the spreadsheet? That would be over the amount you stated for that year,
Yeah.
correct?
The only thing I can think of is that when he did this testimony, he didn't have the actuals at that time. He used his budgeted numbers. I don't know. They're charged to one account, so they're easy identifiable. So obviously there was an incorrect calculation there. Low, but an incorrect calculation.
Just to clarify, are you saying the 509,000 figure in Mr. Kostansky's rebuttal testimony is not correct?
That's what I'm saying. Yeah, that's not the account balance. Unless he included something else in that, that's not the account balance. The account balance, where we charge the filter media change out to, maybe other costs involved with it, because sometimes we have to repair, the vessels. Sometimes there's charges that may not go directly, but I just went back and looked at the filter media account. I took, a few moments to go do that. But if there's other things that occur, like we have to dispose of the filter, that could be another cost. If we have to repair the vessel, that may be a cost because you have to basically take these vessels down, empty the carbon, renew it. If there's any changes or, expenses associated with repairing the vessels, we'll do it at that time. Alls I did was go to the account that is the media itself. So that's the best I could do with the time frame I have. If you would like a specific number, we'd be more than happy to put that together for you.
Yes, we'd like that. And so just to confirm one more time, the operating expense for filter media for 2025, you're saying is over 661,000, subject to check.
It's subject to check. And again, there's a couple costs there that I couldn't get into in the time frame I had. I just checked the filter media. That's all I checked. So there could be other things in there. I'd rather be confident in my response rather than taking a quick check that I just did in a break.
Excuse me, pursuant to my recent comments, by when do you think you might have that, Mr. Spate?
We could probably do it in a couple days. Easy.
Take a week. Thank you very much.
Wouldn't take that long. But thank you.
So we're done with Mr. Koskanski. Were you here for Mr. Christopher's testimony?
I was.
So there was a few questions there where Mr. Christopher also deferred to you. So I'm going to walk through some of those items with you now.
That's fine.
What services did the OTC Markets Group provide that are reflected in the $15,740 that the company is seeking to recover in this case?
We have two classes of stock. One is the Class B and one is Class A. Class A is on the NASDAQ, so we pay fees for that. And it's based upon number of shares, so it doesn't really matter which way you go. The OTC is for the Class B shares. It's a smaller amount of those shares, but again, it's by number of shares. So it's basically for the same service, but one has to be over the counter, the other one's on the NASDAQ. So.
And do you recall that I discussed with Mr. Christopher the Pennsylvania Institute of Certified Public Accountants costs?
I did.
What do those costs represent?
Those are the fees associated with at least one. I believe it's two of our CPAs that continue their license. So that's just for their membership fees in those associations. So they get their education, et cetera, through those organizations, and they maintain their licenses through those organizations.
The membership required for them to maintain a CPA license?
It's how they get the educational credits. They go through those agencies. It's the easiest way to, keep up to date with your education. So that's why they utilize it. And that's why the company supports it. So they maintain their CPA licenses.
And do you recall that I discussed with Mr. Christopher the FMLA leave manager costs?
I don't recall, but go ahead. Yes.
Can you explain what these costs are?
FMLA.
FMLA leave manager costs. They're listed in the social and service clubs dues.
The FMLA would be the Family Leave Association. It has to do with keeping up to date on the laws and regulations surrounding family leave. I know that's been a big issue over the last several years, and recently enacted legislation that the company follows.
So they do not represent dues or memberships in any social or service club. Is that correct?
That's correct.
No further questions from staff.
Crumpler.
Yep. No, they're fine.
All right, sir. Starting off here, I submitted a bunch of documents. I'll need you to, yeah. And while you're shuffling the papers around, if you can get Mr. Watkins' direct testimony handy. Thank you.
I haven't.
Okay, great. Sir, I just want to to clarify, Artesian's rebuttal requested increase is $8,971,713, correct?
I'm sorry, say that again.
So your Artesian's rebuttal requested increase?
Oh, correct, right.
Okay.
Yes.
Okay. All right. And then looking at your rebuttal testimony, you have a copy of that handy?
I do.
Okay.
Just let me get to it.
Sure. Take your time. A lot of paper.
All right, I have it.
Okay. All right. And if you can turn to page 5 of your rebuttal testimony. Okay.
Have it.
All right. There you talk about construction work in progress, CWIP, and allowance for funds during construction, AFUDC, correct?
Correct.
Okay. And looking on page 12 of Mr. Watkins' testimony, he talks about those items as well, correct?
Oh, there. He talks about it in terms of double counting. Yes.
Okay. And you're in agreement with him on that?
No,
No?
no, I'm not.
Okay.
That's an incorrect construction of how those two methodologies are used.
All right. Well, with that, want to turn to some of the documents, specifically looking at DPA 5.4.
BPA. I have it.
All right. And in that document, it's mentioned AFU DC and then also CWIP, correct?
In 5.4, I say, please see attachment DPA 5.4, but I don't have it here. I don't have the attachment. Oh, wait a minute. I'm sorry. You double-sided paper. You're saving paper. I got it. You guys like this tiny print stuff. Uh, uh, and you're referring to the schedule that's attached, I assume.
Yes.
And on there, we show AFUDC, contract labor, materials, planning, overhead, such and such and such. I don't know the context. That's what was asked for. Total booked.
And then, so I'd ask that it be moved as exhibit, I forget what we're up to at this point. 70?
Move,
70.
moving into the record as Exhibit 70?
As exhibit 70.
Yes, sir. Ms. Workman, do you have?
Oh, sure. Sorry. It's DPA 5.4.
No objections from staff.
No objections, Your Honor.
Moved into the record without objection.
All right. And so, and that document refers to both AFUDC and CWIP, correct?
That's what you requested, or that's what DPA requested. Yes.
All right. Moving on to the next document, DPA 5.6.
I have it.
Okay. And that document also talks about AFUDC, correct?
Yes, it does.
Okay. And a few minutes ago, you mentioned that you disagreed with Mr. Watkins about his statement about double booking, correct?
Absolutely.
Can you tell me why?
I'd love to.
Well,
I actually teach this stuff, so I'd love to get into this, but I'd bore you all. But let me talk about what's being done here. There's two methodologies that are used to account for the cost while constructing an asset. The two methodologies are using including a project in rate base. We call it the QUIP methodology. The other methodology is applying AFUDC, which capitalizes the interest expense, but it's supposed to recognize the interest expense as the project's being constructed. So if you include AFUDC, you're just taking the interest carrying costs, as it were, off the income statement, and you're putting it into the cost of the project. So you're recognizing the carrying cost of that project as it's being constructed. The other methodology is, we call it the QUIP method, but really you put the project into rate base, and then the customer pays for the carrying cost as it's being constructed. Once it's put into rate base, all of that goes away. But they are in. You want me to explain? So,
I'm not going to let you keep on explaining, actually.
oh, okay. I thought you asked me to explain.
Explanation, but I just want to clarify because I want to keep things moving along, okay? Because on page,
Objection, Your Honor. He asked a question.
I asked a question. It's my cross examination.
I always lean toward letting people explain. And not, Mr. Please explain quickly.
Okay. Yeah, the last piece of that is the two methodologies can be interchanged. In other words, if the commission orders the company to use AFUDC and it previously allowed the amount to be included in rate base in the form of QUIP, you just stop, take it out of the rate base, and you start accruing AFUDC because it's meant to capture the interest or the carrying costs going forward. It's never, you're not double counting, you're just recognizing the interest expense as you go along.
Testimony says one way or the other.
Yeah, and you can do it in the reverse too if
That's enough. We don't need to do it in reverse.
okay. Yeah, either way.
All right, I didn't mean to cut you off completely, sir, but my question is on page 5, you say there can be no double counting, as Mr. Watkins suggests. So what are you? I'm a little confused. You're not agreeing with Mr. Watkins'
I'm
testimony?
not agreeing with Mr. Watkins at all.
Wait,
You can't double
Wait,
count.
hold on, sir, please. You just said there can be no double counting, as Mr. Watkins suggests. That, to me, that demonstrates you agree with him in some respect.
I think you just said that I don't agree with Mr. Watkins as it's presented, period. You cannot do that. I mean, the way the methodologies are used, you're only representing the cost, the carrying cost at the time that methodology is in effect. Once it changes, then you're only carrying the cost when it's into effect. You're not double counting anywhere. You're just you're just recovering the carrying costs or representing the carrying cost at the time that particular methodology is in effect. You can switch anytime. It's still only the amount at that time.
Okay, all right. I think I understand. Moving on to the next document, DPA 5.7. Do you have that, sir?
I do.
Okay. Now in the company's answer, you objected, but could you at least confirm that Artesian accrues and records AFUDC on construction projects, and that it's reflected in the company's plant and service included as part of a rate base?
Well, let me be clear.
Okay.
The question says for each uniform system account relating to plant and service as of September 30th. So there's no timeline. So that in concept is from the beginning of time to today. So there were projects long ago in rate base that we actually included QUIP in rate base. So I could never go back and try and figure out which projects included AFUDC or didn't include AFUDC from the beginning of time. We have projects that are 100 years old. So just qualifying that, I've tried the best I could to tell you there's no way to do what you asked for.
Okay. Fair enough. Now, I'd ask that be marked as exhibit. What are we up to now?
71.
71. It is, sorry, Kate. It is DPA 5.7.
No objections from staff.
We're asking that to be moved into the record.
Yes, Your Honor.
Ms. Workman,
No objections.
No objections, Your Honor.
without objection, moved into the record as Exhibit 71.
Right. Moving on, sir. Now, looking at page 11 of your rebuttal testimony. You there?
I have it.
Okay, great. This is about acquisition adjustment. You state towards at the bottom, Mr. Watkins also does not provide any analysis of the evidence Artesian presented in its case in chief in this application. But if we actually looked at, sorry, give me 1 second. Page set, if you could refer back to Mr. Watkins' testimony at page 7 and following.
I see that.
Okay. And that keeps on going until pages 10. Okay.
Correct.
And also his GAW4. You're saying that doesn't constitute analysis at all?
No.
No?
The analysis that we provided of the synergies and the value of buying those systems and why the acquisition adjustments were appropriate were cost justification. All those things that the company had submitted in the last case and in this case were completely ignored. The only thing that was brought up was some case that they brought up, both staff and DPA, regarding Shady Park, which the company didn't even bring up, but did point out that the elements associated with these acquisition adjustments deal with whether or not there's benefit to the customers of the company and benefits to the customers that are being acquired as to whether or not acquisition adjustment is appropriate. In the Shady Park case, they actually talked about that it's a small company. They couldn't keep up with
What happened in the Shady Park matter?
In the Shady Park matter, the commission indicated that, it was a small company. They couldn't keep up with their treatment processes, and it was good for the company to take it over. Basically, I'm paraphrasing. We didn't point to that, but it was a case where they approved that acquisition. In the other case with Tidewater that Mr. Watkins brought up, they disallowed their case. We don't know why, and I didn't go in through all the matter. The point was it's supposed to be addressed on a case-by-case basis. In this case, the only thing he looked at was the financials and then pointed to the MFRs to say it's only based upon original cost. That's not an analysis.
That's not analysis.
That's not an analysis, no. He didn't look at any of the reams of paper we submitted in support of the acquisition adjustment, that including Mr. Konstanski went through here today.
Okay, so you're telling me that this chart that he provided and the multiple pages which when he talks about this, that doesn't constitute analysis?
The only thing he went through is the recitation of the MFRs and that it has to do with the original cost basis of it and a chart that we provided, which is nothing but the cost. That's not analysis of the synergies that we provided in both 23-601 and this case. There's a whole testimony regarding the synergies and the benefits of the customers of both companies, and he did nothing to look at those to suggest they were either appropriate, inappropriate, whether or not there was value in the systems that were being acquired, including tanks, including some of the other wells and additional supply that we garnered. All that's called analysis. None of that is here. The only thing that's here is dollars.
That's your perception of what analysis is.
A full analysis capable for the commission to make a decision about an adjustment in a rate base? Yes. This is not an analysis.
Briefly, on the issue of filter media expenses, when did the test period end?
In this case, 9/30/2025.
Okay. And what was the amount in question?
In our 3B4, we had
Yeah.
included 1.6, roughly 1.6 million in normalized expense over the next rate effective period.
Okay. Okay. All right. Moving on quickly. And on the issue of, sorry, give me 1 second, sir. Talking about the issue about tank painting on page 25 through 27 of your rebuttal testimony.
25. Yes, I have it.
All right, and I believe you state that you have a contract over the next 3 years, correct?
Yes.
Okay. And there's a disagreement between you and Mr. Watkins on this issue?
There's no agreement. There's not a disagreement about the contract. There's a disagreement with his extrapolation of information arriving at his adjustment.
And what do you mean by that, sir?
He takes the contract amount for specific tanks and imposes that cost as if it were effective for the other, and I forget how many tanks there are, but we have a total of 24 tanks. So he took those costs for those specific tanks and interpolated that as the cost for each of the other tanks, and then divided by the number of years he suggests is the amount of time between tanks of 17 years. That's a complete fabrication. That's an estimate of tank costs, not even taking into account the types of tanks, the size of tanks, whether they're elevated, whether they're standpipes, whether they're, composite tanks, or whether they're pedestal tanks. So it's a complete, extrapolation of costs that are specific to the tanks that are being painted over the next 3 years, known and measurable.
Okay. All right, and finally, I believe you and Mr. Watkins have a disagreement on rate case expenses, correct?
Yes.
And there's one final document which is labeled Finding and Opinions in Order number 8816 and dated from January 19th, 2016. You have that, sir?
Is that what you provided me?
Yes, sir. Okay.
And where are you looking at?
I'm looking at specifically,
No.
and well, let me ask you this. You were working for Artesian back then?
I was.
All right. And looking at page 98, do you remember this case?
I do.
Okay.
In fact, I talked about it, I believe, in my rebuttal.
And what did the commission say here?
They approved a particular level of rate case expense in our case.
And
they called it well, I have to see exactly what they said here.
I'm looking at it says we are of the opinion that 30 months is the appropriate period for normalizing these expenses.
I see that.
So they use the normalization.
They use that term, but as I stated in my testimony, I believe that's an incorrect characterization of what actually happened.
Well,
see earlier in the discussion why.
Okay, so you're stating that the commission and its finding used the wrong term and it's providing a conclusion of law and fact?
Yeah, I'd love to explain. I mean, there's in the discussion in the hearing examiner's report.
Well, let me ask
talk
you.
of a
Okay, let me ask you this: do you recall Artesian appealing this decision at all?
No, the decision was fine based upon the facts. And again, they allowed a 3-year amortization of certain costs and a 5-year amortization on the comp study and the depreciation study. That in and of itself suggested that the remaining amount of the compensation study and the depreciation study should be recovered later, or why would they only give it a 5-year amortization over a 3-year normalization?
But
None of that made any sense.
Okay, but Artesian never clarified with the board about this, or it's because you were fine about the
We talk to people about the order. The order and adjusting the order is not an easy thing to do. And at that time, there was no adjustments to be made. Could we have made it? We tried. But
When you say you tried, what did you try?
when we, in almost every case, staff, DPA, and company are provided a chance to look at orders. There are some times where orders just aren't changed. The words just don't mean a whole lot.
Oh, wait a minute. You just said the words do mean something, and
They do to me. They do to you. To me, there's a 5-year amortization for compensation study and depreciation study. 5 years, right? So they included that amortization of that 5 years in this case over a 3-year period. So what happens to the last 2 years? They're disallowed? The commission never said they were disallowed. They said, we're just going to normalize, we're going to do this over a 30-year amortization. That's what the 30-month. They didn't address the
sort of
5-year
struggling to hear to
amortization.
get your point of view, sir, because you're saying words matter at one aspect, but then another point, oh, it doesn't really matter.
They have been interchangeably used, unfortunately, and confused. That's all. That's what I'm saying. If they're giving us, and you can see it in the hearing examiner's order, they gave us a 3-year on one aspect, they give us 5-year on the other. And overall, that came out to this amount, which the commission said that they would charge over the next 3 years. So we divided all that by 3 and came up with a number. But the way you amortize things, that would leave the 2 years worth of amortization for the compensation study and the depreciation study left unrecovered.
All right. So just to clarify, though, this is a commission order, correct?
Yes.
And this commission order talks about normalizing, correct?
It says normalization. That's the word it
Okay,
used.
that's-
Normalize over
those
3 years.
Those are the words it uses.
Yep.
And you Artesian didn't contest these terms.
And it didn't deny recovery of the other 2 years
It's not
for
my
the
question.
compensation study.
Sir, that
Gentlemen, excuse me,
was.
Mr. Crumpler, excuse me. I think we've beat this horse into the ground. I think we understand your position, Mr. Crumpler, Mr. Spate. I think we understand your position.
Right. Well, I'd ask that this document be admitted as exhibit, what are we up to, Steve? 72. It's findings and opinions order number 8816 PSC docket 14132, and it's from January 19th, 2016.
Do you have objection, Ms. Workman?
No objections.
No objections, Your Honor.
Without objection, is entered into the record as exhibit number 71? 2.
Those are all my questions at this time.
Are there going to be redirect from you, Ms. Emerson? Before we, that's a question, but not an invitation to start. Are you going to have some redirect, and how long do you anticipate it being? And I'm trying to get a feel for where we stand here today.
All good questions.
I have one that I anticipate will be very brief, and then I understand.
I'm sorry, I can't hear you, please.
I have one question that I understand will be very brief, and then I believe we have 2 staff witnesses that we would like to call this afternoon.
I'm sorry, you have one more question. You have one,
I have one redirect question for Mr. Spake,
and then
and then I believe there's 2 staff witnesses that are available to be called this afternoon.
2 staff witnesses. I'm sorry, I don't understand.
I think what she has one more question, Your Honor, but there are 2 witnesses of staffs that are ready to go if Your Honor is willing for us to extend the proceeding for
2
another.
witnesses of staff? Are we thinking about trying to do that today, Ms. Workman?
Yes, I think everybody would like to have this all done by the end of the day tomorrow. So we want to put as many people today as we can.
Let's proceed. As long as it's a
Mr. Spake,
court reporter, okay? Okay.
Mr. Spake's limited to the questions that you were asked. Do you have anything that you wish to clarify at this point
Limited to the questions I have.
that you were asked on your cross-examination?
I think we went through the AFUDC, and I think we went through, yeah, let me just double check. I thought about a couple of things. The only thing I would say on going back to the benefits statement, I want to make sure I'm clear on this. We know what the company provides as benefit, and I tried to be as clear as possible on this, and we've made tremendous adjustments as it relates to the underlying coverage in terms of deductibles, in terms of what's covered and what's not covered. Those gave rise to reductions in the premium costs that we had to pay, which yielded to the benefit overall of expense going forward and keeping our expenses in line. That doesn't show up in the premiums or the 2% reduction. It does show up when you couldn't do something like on the dental side where we had to increase the amount of participation that the employee made. I don't know what the level of benefit the state employees have. So when I make those comparisons, I'm looking at, just the overall effect of the benefit package, talking with the people that come in for jobs and people that we've hired. So it's an overall feeling. It's an overall topside look at what the benefits that are provided and we can't compete with. We try to do it on the compensate the wage side. So I wanted to be clear on that. There are underlying things in the health and benefit mix that aren't apparent when you're looking at the dollars. And I know there was a question on debt from the parent company, but I don't know that came up in any question. So I know somebody had a question on that. And
I had a question about that.
And you didn't ask it, so I can't respond to it. But I can respond to that if it's still up for grabs.
I mean, the question, as I recall, was basically the debt associated, I guess it was with the subsidiary versus the parent.
Correct.
And they're obviously linked, aren't they? The subsidiary and the parent.
No. The way I've issued debt, the way I've issued debt over the life that I've been here, and any long-term debt that's been issued by the company has been issued in each of the regulated subsidiaries. So Artesian Water Company, Inc. has a first mortgage bond that is solely charged to the water company. In other words, those documents are just at the water company level, the Artesian Water Company level. They're held by the assets of the water company specifically. It's a first mortgage bond. All those bonds have gone through this Public Service Commission, so all that information is available. On the wastewater side, same thing. The long-term debt has been issued by that company specifically based on the assets of that company. And then Water Company in Maryland also has its own debt issuance, the long-term debt. We just did that at its level. None of those are issued by the parent company at all. The parent company does not issue debt. They hold a line of credit that other people can use, but those are charged directly to the subsidiaries. They are not floated down through the company at all. So there is no debt issued at the parent company level, none.
I have a question. You have a further question?
I do not.
Mr. Spade, I'm going to ask you the same question that I asked before on a different issue with respect to the issue of the cost versus the acquisition costs, the upgrade, so to speak.
Yeah, the differential.
The differential. Can you quantify the differential and about what that means in terms of the revenue numbers? Ballpark?
Yes, I can. Actually, it's in both of our testimonies here. I'll just use round figures if you don't mind. It's probably it's a little over $3 million in rate base, which accrues to about $300-some thousand on the expense side, both through recovery and depreciation. A little bit over $300,000.
Thank you. That's what I wanted to know.
May Mr. Spake be excused?
I'm sorry, please.
May Mr. Spake be excused?
Getting late.
Yeah.
He's done with me.
So that's a very difficult question. I'd like him to hang around just in case, but yes.
The screen just went off.
I'm sorry, please.
Do I leave this here?
Your Honor, the company has no more witnesses.
Thank you. I guess we would start next with staff. Staff has witnesses on file, on file, on tap.
Yeah, so staff plans to call Larry Blank and then Joshua Bowman today, and then I think we'll be done for today.
Yep, that'd be fine. Let's call Mr. Blank. Is Mr. Bowman going to testify in person?
Yes.
Would you state your name, please?
Mr. Blank.
Mr. Blank, can you hear me?
Barely. Maybe speak a little more into the microphone.
Would you please state your full name?
Larry Blank.
Sir, do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
Hi, Mr. Blank. This is Stephen Ferguson on behalf of staff. Can you hear me clearly?
Yes.
Do you have a copy of your direct testimony submitted in this case in front of you?
Yes, I do.
Is it a true and correct copy of your direct testimony?
Yes.
Do you have any changes to your direct testimony?
No.
If I asked you the same questions today, would your answers be the same?
Yes.
Thank you. Your Honor, Mr. Blank's direct testimony has already been admitted as Exhibit 20, and Mr. Blank is available for cross-examination.
Very good. Ms. Emerson, would you like to start?
Good afternoon, Mr. Blank. Can you hear me?
Yes, ma'am. I hear you well. Thank you.
Mr. Blank, you conclude that the company did not comply with the prior settlement requirement for a demand study, correct?
Correct.
And because of that, you recommend that the company's cost of service study should be given no weight, correct?
I think that's a fair way to characterize my testimony. Yes.
And you cite the company's response to DPA data request 1.1 in your testimony, correct? That would be at page 3, lines 18 to 20, page 4, lines 1 to 22.
Yes.
Your Honor, I just referenced cross-examination exhibit 5. I will move into evidence at number 73. Is there any objection? That's
Any objection? Mr.
No objection.
Ms. Workman or Mr.
Said it's 5.
Yes, it's CE5. You each have a binder of cross-examination.
No objection.
Thank you. Submitted into the record.
Thank you. And in that response, the company explained that it does not have hourly customer consumption data, correct?
That's part of performing a formal demand study. That's why they have no data, because they did not do the demand study. Yes.
And so therefore the customer could not, you would agree that the M1 manual, the AWW M1 manual itself provides a less sophisticated method using available system data when detailed hourly data is not available, correct?
The manual defines a formal demand study, which was not followed here. There is an alternative method that the company has followed, but it's not what was agreed to in the settlement.
And the AWWA manual does not require utility to generate data it does not have, correct?
The manual defines what a formal demand study is, which requires the collection of the data required.
Your Honor, I'm referencing what is cross-examination exhibit 17 and would move that into testimony as 74. It was not produced per your direction for all parties due to its size, but the court reporter has a copy in its full size. I will mark that as 74 if there's no objections. Okay.
No objection from staff, Your Honor.
Objections from the DPA.
So moved.
And the manual specifically provides alternative procedures using existing system and billing data when the detailed data is unavailable, correct?
No, the manual defines what a formal demand study is.
Mr. Blank, I wasn't asking about the formal demand study. I was
The answer is
asking about
no.
the less sophisticated method using available system data.
Please state your question again. Sorry.
Does the AWWA manual specifically provide procedures using existing system data and billing data when the detailed data is unavailable?
Yes, I've already answered that question.
Okay.
There is an alternative method that's not consistent with the settlement.
And Mr. Blank, I'm not looking for your legal interpretation of the order, but rather what the AWWA M1 manual says. And your response that it does include the less sophisticated method when the data is not available means that the company, since that data is unavailable, could not perform a study based on daily and hourly consumption, correct?
That's false. No.
Okay, so you're stating that you disagree with the less sophisticated method in the manual?
No, the manual describes data collection as part of a formal demand study.
We're talking about the less sophisticated method that's in the M1 manual.
Please give me a reference.
Did you perform an analysis of the company's system to determine what data is actually available to it?
I did not perform such an analysis.
And did you determine how many customers would need to be metered to produce the type of hourly data described in the AWWA manual?
I would suspect, okay, the data collection would require a sample. And the sample could be as many as, for example, the residential class, perhaps 100. But no, I did not perform a specific analysis to render an accurate opinion on that. But it's a sample of customers.
So you would disagree with assertions that a sample might need to be as much as 25% of the company base?
Do you have a reference for that?
I'm just asking you if you would agree or disagree with that assertion.
I disagree.
And did you calculate the cost of deploying the sampling approach that you recommend for the company?
No, I did not.
And you testified that you did not know the expected cost of performing the formal demand study, correct?
That's correct.
On page 4, lines 25 to 28. So when you characterize the company's explanation as overstated, That's not based on a cost study or a system analysis of the company. Is that correct?
What's the reference?
So on page 4, line 25 to 28, you said you don't know the expected cost. On page 4, lines 27 to 28, you stated that the description of needing AMI is overstated. And you just testified here that you did not calculate the cost. So my question here is, so when you characterize this as overstated, that assertion's not based on the cost study or a system analysis. Is that correct?
What seems to have been overstated by the company is the requirement that there be AMI. It gives the impression that AMI is required for all the customers, when in fact, such a study requires a sample. And so that's what I meant by overstated.
So did you design or perform a sampling-based demand study for the company in this case?
That would have to be directed by the company, no.
And did you provide the commission with such a study?
No, the company committed to do that.
So are you not offering the commission an alternative cost of service study?
An alternative cost of service study or a demand study?
Cost of service study.
No.
And are you asking the commission to disregard, or the hearing examiner to disregard, the company's study without providing a replacement?
The cost of service study guides rate design, and I've provided rate design recommendations. So yes.
And your recommendation requires the existence of hourly demand data, correct?
Which recommendation?
Your recommendations for the cost of service design?
To perform a formal demand study would require sampling to provide the hourly demand data.
Which the company does not currently have, correct?
That's correct, because they
How
haven't
many
done a study.
water
Hold on,
utilities?
Your Honor, can he just finish his answer?
I said that's correct because the company has not performed that study.
Not performed this study in the manner that you're recommending, correct? We have performed a cost of service study. Is that correct?
In the manner described by the M1 manual, the AWWA M1 manual that is cited in the settlement of the last rate case.
In terms of the less sophisticated method in the M1 manual with which you're familiar? That's correct?
I'm sorry, what's the question?
You stated that the company has not performed the study in accordance with the requirements of the M1 manual, and I said in accordance with the less sophisticated method described in M1 manual with which you're familiar, correct?
There's an alternative method. The company followed that.
Okay, thank you. How many water utilities have performed the demand study that you suggest Artesian should perform?
I don't know.
And subject to check, would you agree that there have only been 2 water utilities that have performed those studies, and one of those was performed by a consultant for Veolia?
Objection, Your Honor. He said he doesn't know.
Move on. Are you aware that Veolia performed a demand study?
Yes.
Are you aware that approximately 1/3 of Veolia Water Company's customers currently have meters that are capable of providing the information necessary to perform the formal demand study?
No.
Are you aware that approximately 1/3 of those customers had required meters already that were chosen for the study?
No, and you're not specifying what type of customers, whether those are residential, commercial customers, but no, I'm not aware of that.
Are you aware that Artesian does not have a customer with meters that are currently capable of providing the information necessary to perform your recommended demand study?
That's my understanding. That's part of the study, is to perform a sample, correct?
In your opinion, how long would it take to identify the required sample of Artesian customers, install the required meters, install the required software, gather the appropriate time series of data, and prepare a study supporting the cost of service in a rate application?
I think it could be done within 16 months.
And subject to check, would you agree that the PSC docket 230601 order 10460 approving the settlement in that case was entered on June 12th, 2024?
I'll accept that subject to check.
Your Honor, I'm referencing that order 10460. It is in the cross-examination hearing binders as CE 15. I would request that that be moved into evidence as 74.
Excuse me, this is what? Could you please describe it again?
This is the Public Service Commission order number 10460 in docket 230601, which approves the settlement order in Artesian's last rate case.
It's not in the docket yet?
It is not, and it's 75.
75, okay.
Exhibit 75, correct?
Yes.
No objection.
Without objection, it's ordered, it is admitted into exhibit, as exhibit number 75.
And then subject to check, would you agree that Artesian filed the current application on April 4th, 2025, approximately 10 months after the order in PSC docket 23?
Excuse me, Miss, would you slow down just a little bit, please?
Sure.
I know you're reading it very quickly and it's a little tough from this side, so just please repeat.
Subject to check, Mr. Blank, would you agree that Artesian filed its current application on April 4th, 2025, approximately 10 months after that order in 230601?
Could you remind me again from your previous question, when was the order issued?
June 12th, 2024.
Yes, that sounds correct.
So even if the company believed that it had understood a demand study required the collection of data in the manner you suggest, given the time frame between the order and this filing, and given your opinion with regard to the time to obtain the requested data, as you just stated, of 16 months, could the company have contracted a vendor to perform the study and provide adequate information in 10 months to include those results in this application?
No, in my opinion, the data would be short.
Okay.
Yes.
Go ahead and continue, please.
You can finish your answer, Mr. Blank.
Yes, it would be short because preferably we would want 12 months of sample data so that the company would capture all the seasonal effects of demand.
We have no further questions for this witness.
Nothing from the DPA, Your Honor.
Any redirect?
Just a couple of questions, Your Honor. Mr. Blank, you just discussed with counsel your recommendations regarding a formal demand study, correct?
Yes, that's correct.
And that was agreed to as part of the settlement in the last rate case with Artesian?
Yes.
Can you explain for the hearing examiner and the commission what the importance is of the class demands that would be informed by such a study?
The company's class cost of service study includes or relies upon some key ratios that would be improved upon by a demand study. Specifically, we have, and these are mentioned in my testimony, base capacity allocators, maximum day ratios, and peak hour ratios. The purpose of a formal demand study would be to develop, provide inputs to develop those ratios. The ratios would be more accurately improved, and because the class cost of study relies heavily, and the results are heavily dependent on those ratios. So that's the purpose of the demand study.
Thank you, Mr. Blank. Your Honor, I have no further questions.
I have a question. Let me ask you this to make sure I understand. I think what we've heard here today and what's in the testimony is that Artesian performed a study that it says is under the less sophisticated manual. You have described what you believe is a better process, a more detailed process, and that you've described the fact that it was seemingly required in the last rate case. My question is, did you take a look at the quote, less sophisticated end quote, process that they used in this case to either conclude that it, under a less sophisticated method was satisfactory, not satisfactory? Did you examine it? Did you make any suggestion or recommendation with respect to the study that was done?
Yes, Your Honor, I did review it. It is certainly, in my opinion, it's an improvement over where we were in the last rate case. It did result in some changes in these ratios. It is a less sophisticated approach. It requires greater estimation. However, in my opinion, it is an improvement over where we were in the last rate case, Your Honor.
Thank you. But you didn't see any glaring errors in it, other than the fact that it's less sophisticated than what you prefer. Is that a fair statement?
That's a fair statement, Your Honor, and I offered no corrections to that method.
Thank you. I have no further questions for him. Any further questions for this witness? Thank you very much for your testimony. Where are you testifying from, sir?
Today, I'm actually in Phoenix for another hearing. I'm testifying later in the week. I went from Dallas to Phoenix, and the temperature has gone up.
Where are your offices?
Home base is in Texas, south of Dallas, sir.
Southwest Dallas?
South of Dallas, about 25 miles south of Dallas.
Okay. I have a stepson in Dallas. Do you know him?
I don't think so.
Thank you very much.
Thank you.
You're excused.
Staff calls Joshua Bowman as our next witness and asks that he be sworn in when he's ready. Do you have a copy of your direct testimony submitted as Exhibit 23 in this case in front of you? Going to be in Binder 3, Exhibit 23.
Yes. You're fine. I thought it would be.
Is that a true and correct copy of your direct testimony?
Yes.
Do you have any changes to your direct testimony?
Yeah, I do. Would you like me to go through them now?
Yes.
Could you speak into the microphone a little more carefully?
Sorry. Yeah, so I have just a couple minor changes to make. The first edit would be on page 2, lines 14 through 19. I don't know what you want to call that, the little listing of the sections of my testimony. Evidently, when I finalized this, I forgot to remove 2 sections that I didn't do in this case, and I handed off to somebody else. So there should be section 4 and 5 should be removed. So it should be introduction, section 1, section 2, background and overview, section 3, staff witnesses and testimony, and then section 4 should be staff's overall revenue requirement. Which means on page 6, line 3, where it says, as the Roman numeral 4, it should say staff recommended revenue requirement there and not with the Roman numeral 6 in front of it. Aside from that, the only other change that I have to my testimony would be lines 12 and 13 on page 6, where I state what the staff's overall revenue requirement reduction. Currently, it says a reduction of $11,415,856 from the company's final supplemental filing of $9,947,858 for a total revenue requirement decrease of a negative $1,467,998. That number, I do not have the accurate number for that to change to, but staff has made some changes to its position, its filed position, since we filed this testimony. So that number would be different based on the changes that staff witness Catherine Hall and staff witness Ryan Pfaff have made to their direct testimonies. But I do not have the specific number right now. Aside from that, no other changes.
Thank you. I have no further questions. He's available for cross.
Thank you. Good afternoon, Mr. Bowman. You're appearing here on behalf of the PSC staff, correct?
Yes.
And PSC staff participates in this proceeding to analyze the evidence and make recommendations to the commission, correct?
Yes.
And the commission ultimately decides this case based on the record developed in this proceeding, not on outside commentary, correct?
Yes.
And that record consists of testimony, exhibits, and hearing evidence presented in this docket, correct?
Can you say that again?
Does the record of this proceeding include testimony, exhibits, and hearing evidence presented in this docket?
Yes.
So your role and that of your consultants and witnesses is to base your opinion on record evidence and accepted regulatory principles, not external views. Is that correct?
Can you define external views?
So views from, let's say, the news, from legislators, from lobbyists, etc.
Okay, can you repeat the question now?
Sure. So your role and that of your consultants and witnesses is to base your opinions on the record evidence and accepted regulatory principles, not of those external views. Is that correct?
I would agree with that.
Have your staff received any instruction from the governor or the governor's office directing you to lower Artesian's rates or ROE in this case?
I am not aware of any such communication.
Has anyone from the legislature, elected or staff, instructed you or staff to recommend lower water rates or lower ROE for Artesian?
I am not aware of any such communication.
Have you or staff been directed by any state official or employee to reduce utility rates in general in your analysis in this case?
I do not believe we have received any such communication as it relates to this case.
Has any executive branch official or staff told you or staff that utility ROEs should be lowered across the board?
I'm not 100% sure.
Should PSC staff take positions in rate cases to achieve a particular policy outcome rather than applying standard rate making principles?
I would say that depends
On what?
on what the policy principle is trying to achieve.
So, are you aware that there's been public discussion in Delaware about utility rates and affordability?
Yes.
Objection. This is outside the scope of his testimony.
Excuse me, say that again, please.
This is outside the scope of his testimony. His testimony is limited to a summary of the procedures, who the other witnesses are, and the recommended revenue requirement.
I agree with that.
Mr. Bowman testifies in his testimony that he was the assigned case manager for this case.
I'm sorry, I can't hear you.
He testifies in his testimony on page 2 at line 7. I am the assigned case manager for this case. I was tasked with reviewing the application and the testimony and accompanying exhibits of each of Artesian's witnesses. I compiled the set of staff's data requests and reviewed Artesian response to said data requests. I also handle all internal coordination between staff, legal consultants, and legal counsel and outside consultants. Therefore, Mr. Bowman is testifying that he is the person responsible for coordinating all of this, which is what I'm asking about.
I think my understanding is that's a fair assessment of what his responsibility is. So what's the question?
So my questions are thus far, and what Ms. Workman, I believe, is objecting to, is the direction that has been given to staff and from staff to staff, legal counsel, and outside consultants.
Which he does not testify about.
I think Ms. Workman's right. He hasn't testified to that. He's testified to what he's testified to.
So he testifies about the Oleus rate increase request and whether there was public comment sessions held. And he testifies about presumably our public comment session and the scope of the affordability concerns there. That's on pages 3 to 4.
All right, so I'll let you make a couple more questions in this regard, but you're getting close to the line.
Okay, so could you answer that question? I believe you said yes.
Can you repeat the question?
Are you aware that there's been public discussion in Delaware about utility rates and affordability?
Yes.
But that public discussion is not evidence in this record.
I would agree with that.
And has that impacted staff's recommendations that you've coordinated in this proceeding?
No.
So your testimony and the testimony of staff's witnesses and consultants here is based on the professional judgment and the analysis of the record, not on the public statements from elected officials. Is that correct?
That's correct.
PSC staff conducts its analysis independently within the regulatory process. Is that correct?
I would say that's correct, yes.
And did staff alter its recommendations in this case because of political or public pressure?
No.
And did anyone instruct you to target a particular outcome for Artesian's rates or ROE?
No.
Have you had communications with legislators or executive branch officials or staff about what your recommendation should be in this case?
No.
And has any such person asked you to advocate for lower rates or lower ROEs in this proceeding?
No.
PSC staff often works with or relies upon consultants or expert witnesses. Is that right?
That's correct.
And you coordinate with those consultants regarding the analytical work in the testimony, correct?
Yes.
That's your role in this case. Did staff instruct any of the consultant or PSC witnesses to reduce their ROE recommendation to reflect public or political concerns?
No.
And did staff tell any consultants that their analysis should reflect desired policy outcome, such as lowering rates?
No. Oh, were you done?
Sorry.
Were you done with the question? I just want to make sure I didn't cut you off. No. The answer to your question was no.
Okay. Did staff communicate to any consultant that state officials expected lower utility returns?
No.
Any expert views presented by PSC staff or its consultants are supposed to be based on their independent application of financial and regulatory principles, correct?
Yes.
Was there a public comment session in this docket on December 3rd, 2025?
Yes, I believe that was the day.
And how many members of the public attended that public comment session?
There was no members of the public that attended either in person or virtually.
You would agree that utility rate making is intended to provide a reasonable opportunity to earn a rate of return sufficient to attract capital, correct?
I would agree with that statement.
And that determination is based on financial market evidence and regulatory standards and not public opinion, correct?
I'm not a rate of return witness, but I would say that sounds reasonable.
So just to summarize, the staff's recommendations in this case are based on just the evidence in this record, the professional judgment of you and your consultants and counsel, and accepted regulatory standards, not on any direction from elected officials or external sources that we discussed, correct?
That is correct.
I have no further questions for Mr. Bowman.
Nothing from the DP.
No redirect from staff.
Nothing from the DPA, Your Honor.
Anything further, Ms. Emerson?
I do not. Thank you.
Thank you, Mr. Bowman. Take the rest of the day off. Ms. Workman, are there further?
Not today.
Not today. Thank you. Then we're adjourned for the day, not for the proceeding. So we'll go into recess until 10 o'clock tomorrow morning.
Before anybody leaves, but when we're off the record,